May I please the Lord? I like to mention this declaration for listing on admission hearing.
When?
Lordship, on 28th November.
20.
Therefore, listing a motion matter on Friday, Lordship, already numbered. Lordship.
When do you want?
On Friday, Lordship, next Friday.
Friday, we have cases, Lordship. On Monday.
Motion matter.
Yes, we have already so many cases.
Okay.
May I please,
On Monday.
may I please, your Lordship, I beg to mention for listing. So matter will come up admission on 7th of November.
7, Friday,
And
on Tuesday, 11th.
complete.
May it please the Lordship, with the consent of the petitioner, Lordship, I beg to mention item 23. Lordship may kindly matter can be
Mr.
listed.
Pupamunya, learned counsel for the respondent in hierarchy of department with consent from the other side. Press for listing the matter on
After 2 weeks, Lordship.
after 2 weeks.
Interim order is there, Lordship. Interim order is there.
Interim order pass earlier self conduct.
Highly obliged.
May it please your Lordship. Lordship, I beg to mention for listing for admission on 12 Lordship. On 12 Lordship. 12 from November Lordship.
What matter?
Lordship, non-payment of SLI Lordship. Oblige your Lordship.
May I please, please your Lordship, I like to mention two petitions for motion Monday.
Monday.
Monday, on Friday, 14th.
My Lord, I beg to mention one item, my Lord, it's relating to my Lord pensionary benefit. If it is possible for admission, my Lord, on 11, my Lord. 11. Oblige you.
May it please your Lordship, Lordship, I beg to mention for listing of an academic institution matter, more than 50 students examination center. Last date is about Monday, your Lordship. May come up on Monday, your Lordship. For motion, your Lordship. On Monday, your Lordship, for motion. Academic institution. Much obliged.
May please, your Lordship.
I beg to mention for come up on Friday, my Lord.
This week,
My Lord.
next week.
On-
Admission, for admission, my
On 13th. 13th November,
10.
10th. Okay,
My Lord, for listing on any day, my Lord, next week,
on 14th.
admission.
Please, Millets, we have filed an IA for stay vacation, Millets. There's some urgency, Millets. The college governing body, by the stay order, it has been reconstituted against the order of the state government, Millets. With either this Thursday or next Monday, Millets. There's some urgency in the matter. The GB meeting is to happen, Millets. Very humble request, Millets. The governing body meeting is being stalled because of the order of this honorable court, Millets. Therefore, we are seeking stay vacation. The governing body of the
Next Wednesday.
Coming Wednesday.
Millets, my learned senior will be out of session Monday if possible, Millets.
Monday already a lot of cases.
Otherwise, Tuesday, 11th.
Monday.
We have. Monday, we have cases otherwise.
Can it be on Thursday, Millets? There's some urgency this Thursday, Millets.
No.
Day after tomorrow.
Already a lot of cases fixed.
Very well, Millets. Monday if possible, otherwise, Millets.
10th.
Grateful.
May I please your Lordship, Lordship, I pray for listing of a read petition, Lordship, on Wednesday, Lordship.
Next Wednesday.
12th.
We are coming Wednesday, Lordship.
Tomorrow is Wednesday.
Next week, Lordship.
Next week.
Yes. Obliged.
Lordship, item number
Well-
6. Affidavit in reply already filed. Kindly list the matter after 2 weeks admission hearing.
After
After 2 weeks admission hearing.
you have put a petitioner.
Petition.
Sir,
In Islam.
and Islam learned for the petitioner. You inform the other side. We'll call the matter.
May I please your Lordship, there is one content case, there is some urgent. So kindly list on Friday.
What one is?
Next week.
What will say me?
On 13th.
My Lordship, second time. No objection. Item number 6.
Okay. With consent from the other side, press for listing the matter after
2 weeks
after 2 weeks. There.
May I
for
please,
admission hearing.
Forward.
may I please, your Lordship? I beg to mention for listing. Petition, Lordship.
When?
18.
18.
Yes, sir. The problem.
For motion, item number 20.
I beg to mention for listing of contempt matter, my lord, 2023 matter.
Wonder one.
Next week, my lord. Next week.
On 14th.
I'm-
For motion, item number 25.
Lordship, actually, we need to reconstruct the file. Milo have been appointed as the BTC counsel very recently, your lordship. Didn't receive got the file.
Hmm.
So matter will be taken up, any other day, coming to your lordship. I'll reconstruct the file, your lordship. Matter will be taken up on Friday.
Coming Friday.
Yes,
Coming Friday.
any other day. Yeah.
On 19th.
Lordship, Honorable Court already directed the BTC to file affidavit in opposition. They have also not filed affidavit.
Council changed. it.
Council, also, Lordship, another date may be fixed. Meanwhile, direction may be given to file affidavit in opposition. Since it is already on record.
Okay. Heard, Mr. A.P. Sarkar, heard.
Lordship, may please to issue notice. Notice has not been issued for that.
And also heard. Steve Oya, learned. Senior counsel, standing counsel for BTC.
Yes, my lord.
BTC. This petition under Article 226 of the Constitution of India, the petitioners are tried for issuing direction. More particularly, respondent number 4 to select and appoint the petitioner for the post of assistant teacher in lower primary school. Assamese medium as well as Bodo medium. Pursuant to the advertisement dated 17/1/2024, issued by the Director of Education, PTC, Kupragat, as well. As considering the marks obtained by the petitioner by virtue of their merit shown in the verification list. First, the petition in the documents by the paper that notice be put to the respondent, the certificate for it. However, no formal notice is required to be issued. Since all the respondents are represented by their standing counsel. Who is for respondent number 1? It's the PK Bora for respondent. However, no formal notice is required to be issued since all the respondents are represented by their respective standing counsel. But extra requisite copy of the petition be furnished to them during the course of the day. List the matter after 2 weeks.
After 4 weeks, then if the lordship is pleased to issue notice.
After 4 weeks.
After 4 weeks. The meantime, the ethnic council for the respondent authorities may file their affidavit in court.
It's your right.
Items for admission. Item number 1 and 2. Part-
Matter may kindly be placed for the time being. Will it come for response number 7 and 8? Mr. A.R. Bhuya is on late, he's coming after some time. Ablash.
Item number 3. Parted matter.
My lord, I have prepared a written argument. My lord. Here in this case, the petitioner before lordship was challenging the appointment of the private respondent.
Have you furnished a copy of the same to Mr. Devan?
My lord,
No, it is a copy of this written argument.
yes, today,
Furnished to them.
my lord. I don't know, my lord, I have forgot, my lord, whether it was earlier submitted or not.
You have received copy of this written record.
My lord.
I-
Yes, you can serve, my lord. You can serve a copy. No problem.
Not only thing, Woman action. If I take only 1 minute, my lord, if your lordship remembers, possibly, my lord, everything has been argued from my side as well as my friend's side, my lord. And only thing, if
Then
your
why the
lordship,
matter is listed today?
my lord,
Then why the matter is listed today?
my lord, the matter was listed, if your lordship remembers, and I think it will be, perhaps it will be in the order sheet, it might reflect. So he is claiming library assistant, if your lordship just recollects, my lord.
Hmm.
He was appointed as a library assistant. Then because he obtained the degrees and at the time of provincialization, he applied for, he was promoted in the school to the post of assistant librarian. So he applied for the post of assistant librarian. He was recommended by the DLC. Then when it was taken up by the SLC at that point of time, because of his qualification which were obtained off campus from outside, and one of the college has been already by our honorable court in a judgment said, no, it is illegal, it cannot be taken into consideration by the state government. At that point of time, and in the meantime, my lord, library assistant, my service was provincial. He approached this honorable court saying that my post, which I was appointed as library assistant, should be given back to me. So both the sides we argued, and at that point of time, my lord only wanted to know from the state, from the Standing Council Education Department.
Last order to.
Last order, it may be there, that only was he recommended by the DLC as assistant librarian, because if that is true, then his case goes. Now he can't turn back and say that I want the library assistant, not the assistant librarian. Otherwise, my lord, I think if I remember correctly, your lordship has noted down both the sides' argument. Only that was required, that standing council had to produce that information, whether his recommendation by the DLC was made as a assistant librarian or library assistant, that much.
Yes, Mr. Das.
My lord,
DLC recommendation is here.
my lord, my argument, my lord, on the last occasion, when the matter was called, while government advocate was also present, Mr. Abedin was not absent, was absent. And case was adjourned for time being. Then, my lord, at two, my lord, I was absent because I was in leg in other court. Thereafter, I hurriedly came, and lordship has allowed me to argue the case on the next date, my lord. Accordingly, the case has been listed today, my lord. So, my lord, I have to make some submission, my lord.
Okay, I will give you the opportunity.
On the red flag, I think, red flag, my lord. There are two flags. One is green, one, second one. This is the format of the recommendation given by the CLC, my lord. Their highlighted portion is there. The name of the petitioner has been recommended as, my lord,
Assistant librarian.
yes, my lord.
My lord, lordship may kindly have a look at, my lord, the records.
And below, my lord.
What was the recommendation of the private respondent?
Below, my lord, the seal and signatures of the committee members of TLC, they are there.
Okay. Yes, Mr. Secretary,
My lord,
continue.
my lord, submission is also, my lord, on the crucial point is on the recommendation of both the parties, my lord. My lord, I was, as per record, I was recommended SK11. And what was the recommendation of the read petition, my lord, private respondent? His recommendation was for junior assistant. and he was appointed in the post of assistant librarian. My lord, library assistant. That was my post, my lord. I was initially appointed as I was appointed by governing body resolution proceeding, my lord, as a library assistant in the year 2006. Lordship may kindly have a look at, my lord, for a refresh, my lord, although it is hard earlier, but for refreshment, my lord, I want to show, my lord, the documents, my lord. Annexure 5 is the governing body proceeding. By proceeding resolution number 2 dated 26/2/2006, I was appointed as library assistant. Then, my lord, the appointment letter is at page 6. Dated 15/3/2006. Then, my lord, my joining report, Annexure 7, page 41. I was allowed to join on 16/3/2006. Since then, I have been working as a library assistant in the college, and I have received the financial assistance up to 2011. Since the private financial assistance has been continued, it is continued up to, so far my information, it is continued up to 2011. I received the financial assistance in that capacity up to 2011. Then, my lord, I was certified. An experience certificate has been issued by the then principal. Annexure at page 42. Annexure 8. It was dated 16/5/2011. May I read, my lord?
Not necessary.
My lord, hereby certified that I have been working. He has been working since as a library assistant since 16/3/2006 till now. So on 16/5/2011, my lord, at least I was working as library assistant, and they are claiming, the respondent claiming that I was upgraded. I was upgraded as a library assistant by another proceeding. I have also annexed that one, my lord, in this writ petition. Lordship may kindly have a look at page 100. Resolution number 5. My lord, Barnacular page may kindly have a look at, my lord. At page 103. 1st number Prostab. Kindly have a look at, my lord, at 103. হাজির হবাই রাজ্জাকুল হুসেনক লাইব্রেরি অ্যাসিস্ট্যান্ট পদৰ পৰা পদোন্নতি দি অ্যাসিস্ট্যান্ট লাইব্রেরি হিচাপে নিযুক্তি দিবলৈ সম্পাদকক দায়িত্ব দিয়া হল। My lord, this resolution number 5, the lighting of this resolution number 5 is not matching with the other part of the proceeding. This is, my lord, one point, that this is a documents has been subsequently manufactured, and the staff pattern which was prepared by the principal. Lordship may kindly have a look at page 45, Annexure 10. Sorry, my lord. Sorry, my lord. It is not page 51. It is annexure in the next page. Next page, 104. 104. This is a staff pattern prepared by the principal. At page 105, one Shohid Yusuf Ahmed was appointed as a teacher of philosophy by same resolution 28/3/2010. 105, my lord, page 105, serial number, main serial number 9, sub serial number 3, Shohid Yusuf Ahmed, assistant professor. He was appointed by same resolution, same date resolution 28/3/2010. But this proceeding does not reflect so. So my submission is that this proceeding, the resolution whereby I have been shown as appointed on 28/3/2010 as an assistant librarian is manufactured documents. My lord, there are so many other manufactured documents, my lord. Manufactured by the college authority of that time, my lord. I want to show, my lord, before coming to the main point, my lord. My lord. No, it was. Attendance register number, no? My lord, it is an affidavit, my enclosed in the affidavit, my lord, its page starts from 123 or 22, my lord. My reply affidavit, my lord.
Yes.
122, my lord. I have this affidavit, I have enclosed some documents. Lordship may kindly turn to page 130. This is the provincialization order for the teachers. My lord, two history teachers are here. One Abul Hussain and Sultan Mahmud. Their history teacher provincialized by this order. And kindly have a look at, my lord, the enrollment, my lord, record. This is prepared by the controller of examination. My lord, kindly have a look at the enrollment history for 2016, 7, 10, then 3, then my lord 18. Then my lord, the student appeared in the examination at page 132. For history department in 2016, only 3 candidates appeared in the examination. Lordship got it?
Page number?
Page 132.
Yes.
132, my lord. Here, my lord, this year of examination 2016 noted in the top subject history. Then, my lord, now total number of candidates present in the exam, only 3. Then, my lord, in 2017, lordship will find at page 135. For history, the total number of candidates present is only 6. Then, my lord, 2018 at page 139, the total number of candidates is only 3. It's a 6th semester examination. Then, my lord, 2018, another 6th semester examination at page 141 is only 1 candidate appear in the history. So, my lord, the law says that for provincialization of any teacher in a particular subject, the student must appear at least 15 in the final examination. Go to step 2. My lord, may I read, my lord, the provisions of law? This is, my lord, prescribed in section 2, sorry, my lord, section 3, subsection 7 in this book, my lord.
No, how it is relevant here?
My lord, I want to show, my lord, I want to establish that the college authority has manipulated the records. This is the example, one of the vital example of manipulating the records. My appointment, the upgradation of a resolution, that is also manipulated documents. The college authorities committed so many manipulation. This is one of the vital manipulation.
No, maybe, but this is not the issue before this court.
No, that is there, my lord. But my claim is that the college authority has involved in so many manipulation of the record. And my crucial submission is, my lord, based on that, the private respondent who has been provincialized in the post of library assistant was also recommended by the DLC in the post of junior assistant. But he has been appointed in the post of library assistant. My lord, my claim is that I have never resigned from my post. And admittedly, the college authority has taken my additional service. Sometimes as a lecturer or tutor as in the post in the subject of philosophy, because I am master degree holder in philosophy. Sometimes I have been also given additional duty to function as assistant librarian. But I have never resigned from my original post, library assistant. I continued. They cannot show that I have resigned. Now the question is, the private respondent, when he was recommended for the junior assistant, he never served in the post of library assistant. He has been, the government has provincialized his service, jumping from the recommendation to the my post. And also, my lord, violation of the relevant law. The relevant law says that at least any incumbent to be provincialized, he should render 6 years service in that post, my lord. My lord.
As per rule,
My lord, section 4, subsection 1, Roman 3 of Assam Education Provincialization of Services of Teachers and Reorganization of Education Manual Institution Act 2017. In this book, my lord, it is at page 114 and 115. Section 4, my lord. Lordship got it.
yes, yes.
Teachers and or tutors to be government servants subject to fulfillment of all other provisions of this act. The services of teachers and or tutors of all branches of educational institutions eligible under section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in the official gazette and they shall become employees of the state government with effect from such date. The teachers and or tutors to be provincialized under this act, it must have been working as a teacher in the concerned Panchar educational institution as mentioned in section 311 that have recognized by the competent authority on or before 1/1/2006 must have minimum educational professional qualification as laid down under different acts, rules, and regulation as mentioned under 6 or any other relevant statutory provision as the case may be. My lord, 3 must have rendered at least 6 years continuous service as on 1/1/2017 from the date of joining the concerned Panchar educational institution, which must be on 31/12/2010 or prior to that. My lord, this is the relevant provisions of law. He never served in the post of library assistant, and I have, their claim is that I have been upgraded subsequently in the year 2010, but I have rendered more than 6 year service according to them. But subject to my objection that I have never resigned from the post of library assistant. And principal also certified me that I am working in the post as a library assistant. And I have received financial assistance up to 2011. And this is the violation of the law, and taking note of this violation, this honorable court, while issuing notice in the case, has granted interim stay, my lord, suspending their payment of salary, my lord, staying the operation of the impugned order. Then, my lord, there was another order of this honorable by this honorable court, whereby this honorable court has directed by order dated 15/2/2004, directing this respondent higher education department to file affidavit to show the justification of the impugned order, particularly the paragraph 3 and 4 of the impugned order, whereby the my case has been rejected and his private respondent case has been considered, my lord. And the state respondent did not file any affidavit to that extent, my lord. No reason has been assigned in filing the affidavit in opposition. So, my lord, my submission is that there has been two things, my lord, happen. That by passing the impugned order, the private respondent has been provincialized, violating these provisions of statutory law, and also jump from the recommendation to the recommendation in the post of junior assistant to the post of library assistant. My submission is that even if my recommendation was made in the post of assistant librarian, but I am in the library, in the department of the library. I am earlier working as a library assistant according to their claim, my lord, up to 2010, but I have received salary financial assistance up to 2011. So I am in the library. So had it been my case is considered for the post of library assistant, what law would have been violated, my lord? There would have been no violation of law. Only, my lord, one thing, my lord, he was jumped to junior assistant to library assistant. At least in my case also, they could have considered instead of the library assistant librarian to the post of library assistant. And in that case, there would have been no violation of law. That is my submission, my lord. And the question of now substantial question I have raised in my written argument, my lord. This first substantial question is whether the appointment of the provincialization of the respondent 7 is permissible under section 4(2) within Roman 3 of the 2017 Act. Secondly, whether the provincialization of this respondent number 7 in the post of library assistant is justified when he never served in the post of library assistant or in the library department. Thirdly, my lord, even if I was claimed to be upgraded in the post of library assistant, assistant librarian, then I could have considered in the post of assistant librarian, and in that case, there would have been no violation of law. And another question is that, my lord, there was no personal hearing was taken by the district level scrutiny committee. There would have been a personal hearing that was not taken. I don't know how my case was forwarded. And his case also, my lord, subsequently we could know that his case is recommended in the post of junior assistant, but he has been provincialized in the post of library assistant. So this is my submission, my lord, and I want to rely, my lord, on judgment. इस नंबर को लिख दीजिए एक्शन लेगी इस नंबर को लिख दीजिए एक्शन लेगी WBC 5544/2023 my lord my lord it's a case reported as 2009 1 GLT 729 1 GLT 729 Manasi Goswami versus State of Assam. My lord, paragraph 23 is relevant for us. 23. Is relating to provincialization of service under elementary division, although in present case is under higher division, but principle is same. Paragraph 23, Lordship got. May I read, my lord?
Yes.
It is inconscionable that the district elementary education officer in the case in hand was unaware of the sanction of the rules. His apparently illegal, irresponsible, and unauthorized act of quitting the petitioner in outright infringement of the rules smacks of impertinent and oblique consideration. Even assuming that in doing so, the said departmental authority had acted as an agent of the government. The order being in palpable violation of the rule is wholly unauthorized and unlawful and cannot bind the government thereby. The ratification of an act of an agent by his principal as comprehended under section so-and-so of the act, which supposes a lawful doing, but beyond the authority conferred, no ratification of an act unauthorized as well as illegal is contemplated thereby. Ratification by the principal is permissible if the agent's act, though legal or lawful, transgresses the bounds of authority conferred. If the act is per se illegal and therefore non-est in law, ratification thereof under section 196, 197 of the act is not conceptualized. Then, my lord, paragraph say 24 also, to some extent relevant. The analogy of liability under section 70 of the act is sought to be drawn in the facts of the case, therefore does not comment for acceptance. The liability of the state being defined by the rules, the same cannot be extended beyond its framework on the strength of quasi-contract, otherwise repugnant there. The district elementary education officer being neither competent nor authorized to appoint petitioner. My lord, this paragraph 23 is relevant to us here. In that case also, there has been violation of the statutory law. And in the present case also, violation of statutory law. So, law cannot be violated. He was recommended for the junior assistant, provincialized in the library assistant, and without having minimum service in that post. That is a gross violation of law, that cannot be permissible, it should be set aside. And I being served in the same post for more than 6 years, I should be considered, my lord. That is my humble submission. Hmm? Hmm. Hmm, hmm, hmm.
Mr. Tusk, as per the recommendation of the PLC, the respondent number 7 was recommended as junior assistant. Junior assistant. Then on what ground the state level committee has sent the same? And where is the SLC resolution?
Speaking order of that.
The recommendation is,
Pardon?
the recommendation is, top flight marks, Malad, I have given, Malad.
That is PLC, SLC resolution.
SNC resolution, Malad, I should take care, Malad, one second.
Kindly show me.
Well, I'll check and
Okay. Yes, Mr. Abedin, anything to submit?
My lord, actually I have made my submission on last occasion.
All
my
right,
lord.
okay, okay.
My lord, only one thing, I'll take only 1 minute to
Okay,
just to bring back my lordship's, my lord, my IO was considered as, thing, my lord. If your lordship take my IO, my lord, IA 85 of 2024.
yes.
My lord,
A was for,
IO was for, my lord, actually, though I am serving, till date I have not received any salary. I am more or less starving. Yes.
we will finally adjudicate the matter. We will finally pass the order.
Yes, yes. No, I want to show that page 68 from there, my lord.
Yes,
68.
yes.
My lord, before I go to this only, one thing I would like to place before my lord, for lordship appreciation, my lord.
Hmm.
My lord, what my friend from the petitioner side has said that when everything was manipulated only to oust him, that is his thing. But my lord, in the writ petition, there is no such pleading that everything is manipulated to oust him. What he's saying, this is the first time before this honorable court. Secondly, my lord, suppose I am a library assistant, a grade 3 post. But where is the scope of me doing anything in order to oust him who is a assistant librarian?
No, no, his allegation is against the police authority,
My lord,
not against you.
and then my lord, only thing is that whether my friend substantiated his right, unless until it is a, my lord, fundamental principle of the writ. If he has to establish his own right,
Hmm.
we just can't, my lord, just say anything of anything, everybody else, unless and until I establish my right, man.
Hmm.
My lord, page 68 is his own application.
Hmm.
Would your lordship be pleased to see once, my lord?
Hmm.
Page 68.
Hmm.
My lord, this is, as your lordship is aware, my friend over here, my lord, is representing the education department. He would, if your lordship puts the question, he will clearly say, each and every individual, they have to give their own format, which has to be submitted to the institutional head before the DLC, my lord. This is his own application, under his own signature. What did he say, my lord? In the second column, assistant librarian,
Hmm.
And at that time, he was receiving so and so amount, my lord.
Hmm.
Now, my lord, see his degrees. If your lordship see the VLIS and then MLIS, last two columns of the degrees, my lord. The MLIS, that 2015 from MKU University. Madurai Kamraj University, Tamil Nadu. What happened, my lord? This was applied in the year 2017 when the act came. As your lordship is aware, my lord, 2011 act. 2011 act was scrapped down with the rider that you form a new act, and the 2017 act came. He applied for this post of assistant librarian. But incidentally, my lord, if your lordship may note down, my lord, writ petition 2983 of 2017. It is given. 2983 2017, my lord, date of disposal is 13/2/2019. Paragraph 18, my lord, of this judgment which I have given, my lord. This honorable court held this off-campus degrees from the outside is not acceptable. And this is the reason, my lord, his SLC did not recommend his name, my lord. Now my friend suddenly turns around and says, you could have given me instead of assistant librarian, library assistant. Is it possible? He is applying, he is educated man, have got the master's degree in library science. He has asked for assistant librarian. He was appointed to that post. And now he's saying that I could have given library assistant. Why didn't they do that? What happened, my lord, if your lordship notice there, your lordship would remember another man who was given that post on that day as a library assistant, but DLC recommended my name only on the ground of seniority. And my lord, one thing I would like to say before my lord, that my lord, this grade 3 posts of junior assistant, assistant librarian, these are not, though at the initial stage from the venture, the government, the education department puts forward the recommendation. Ultimately, as and when they become, they are appointed, they are not regulated by education department rules, my lord. In fact, they are regulated by the Assam Ministerial District Establishment Service Rules to 1967. I think that is already noted, my lord, in my, while I was making my argument.
1960?
7. So, my lord, my only thing is that the petitioner could not make out a case for any kind of interference with this provincialization, my lord. He could not establish anything that I have taken his post, nor he could establish that he had any kind of right to the post of library assistant. When he was already in the year 2010-11, he was already taken the post of assistant librarian, and page 68 clearly shows.
So now you tell me, while the district level committee has recommended you as junior assistant, how can you be appointed by the SLC as a library assistant?
My lord, over there, I think in one of the, I think in the impugned or subsequent order, it was clearly written by the impugned order that it was clearly written on the ground of seniority, I was considered as a library assistant, because junior assistant and library assistant are similar posts. And my lord, that one Abul Kalam Azad who was recommended for that post, he was much junior to me. I'll not go into that, my lord. Actually, headmaster put my name in the junior assistant and that Abul Kalam Azad for library assistant. But ultimately, the SLC found that I was much senior, giving service to the institution since longer time. And they considered me as the library assistant because those are the posts to be provincialized at that point of time. But my lord, my getting that post in place of Abul Kalam Azad, my friend he cannot make any argument on that, my lord, because he is nowhere involved with that post. In the year 2010-11, when he was given the post of assistant librarian, he has forgotten everything. I don't come his way, nor he comes in my way. And it is, my lord, he cannot just say, if I was not given the assistant librarian, they could have given me library assistant. It's a two cadre post, 2 and 3. It's not possible. And all along, he was taking the benefit of the assistant librarian. He applied for that post that was recommended. That was recommended by the DLC, District Scrutiny Committee. Ultimately, in the SLC, because of his qualification, he was dropped. And what qualification, my lord? I've just given out, my lord. In 2019, that MKU was said to be illegal degree in another case. Though this over there, my lord, master degree is required for the principal, and ultimately the man became principal because this court said, no, you did not have even the master degree. How can you become the principal? We are nullifying that. And it was nullified in this manner. And because of this, now he is turning. When he found that his degrees are illegal, I don't know how he could take so much of degrees while at the same time serving in the institution. Okay. The only thing, my lord, writ petition should be dismissed
Mr.
because he.
Have you got the copy? Mr. Secretary, is the resolution of the SLC is part of the record? That SLC resolution is part of the record? No.
SMC resolution of 2000 of,
By which the claim of the petitioner was rejected by the court.
my lord, my claim was rejected by initially by
What my lord was looking, that is in the writ petition page 98. My lord, when the writ petitioner in the earlier round of litigation.
Hmm.
My lord, in the writ petition,
Got it.
what it, my lord?
Annexure 8.
My lord, Annexure 8, before going to Annexure 8, my lord, would your lordship be pleased to see page 84. It starts from page 82. My lord, this is his own writ petition and this is his own order. It is filed by him only. My lord, let's come to the page 84, my lord.
initial order.
Yes.
My lord, it is the subpara during the deliberation. My lord, got it.
Mhm.
My lord, it's important, my lord, these two paragraphs.
Hmm.
The lordship may just mark it, my lord. What my friend is saying now, that was already taken care of at the time of his earlier writ petition. During the deliberation of the matter, Mr. Sikdar, learned counsel for the petitioner, on instruction, submitted that the petitioner does not have the requisite qualification to be appointed as an assistant librarian in the said college. So assistant librarian, he was all along seeking. But at that time, he said he did not have the qualification because that qualification was already nullified by this honorable court in the 2019 judgment, my lord, which I have just given. My lord, on instruction, Mr. Sikdar, learned counsel for the petitioner, further submitted that one Saleha Khatun, whose service was provincialized by the impugned order dated so-and-so as junior assistant of the said Janapriya College, expired after provincialization of a service, and as such, the petitioner may be considered for provincialization of his service against the said vacant post considering his service in the said college since so and so.
My lord.
Yeah. So that was, at that point of time, nothing much against me. Either wanted the assistant librarian, he did not have the qualification, then one post, which the provincialized person expired, he wanted to be accommodated over there. And then this case was remanded. This was remanded by the next, my lord, ultimately this writ petition was finally disposed, remanding the matter, my lord. See the order 98. Page 98, annexure 18. My lord, got it.
Yes.
My lord, this is the report on the appeal letter of Sri Rajakul Hussain and Honorable Guwahati High Court order dated so and so in WPC number so and so regarding provincialization service of library assistant at Janapriya College so and so. My lord, 1, 2, 3, 4. This is the 5th paragraph, my lord. My lord, the service of Babul Hussain. My lord, got it. The service of Babul Hussain, who was originally appointed as junior assistant with effect from 9/12/2006, has been provincialized as library assistant considering the seniority of date of joining and eligibility of post for the college under relevant act in force. That's all, my lord. He cannot find, he cannot say anything about my post and my provincialization. He has to substantiate his own right. And he miserably failed, my lord. On that ground, this writ petition should be dismissed, my lord.
My lord, may I say, my lord, few words, my lord. My lord, here, my lord, my friend is saying about my degree. My lord, I am MA from BA from Guwahati, under Guwahati University. MA also. A part of those degrees which are not valid, I admit, my lord. That is librarian certificate relating to library course. So that I have no validity, I am also not claiming. My submission is that when the private respondent has been recommended for junior assistant, he never served in the post of library assistant, and he has been provincialized in that post, violating the settled law that he never served 6 years or any period. Whereas I am in the same department. I am in the same department, library department. If he could be provincialized in that post, jumping about the law, violating the law, why I should not be considered in the post of library assistant, wherein I have rendered service? That is my humble submission, my lord. And the so far the documents in page 68, my application, that application, my lord, that application, there is no date
No.
mentioned.
Mr. Sector, the qualification for both the posts, the library assistant and junior assistant are same.
Yes, my lord, that is same, but he has never served in that post. How he can be? And he was recommended in the junior assistant post. Kindly see, my lord, the records on that. Where, for which post he was recommended? If he is not recommended for the library assistant, how he can be appointed in that post? Why jumping, where violating the law? Hey, if he can be appointed
But,
by
but,
violating the law,
Mr. Sector, you have applied for the post of assistant librarian.
my lord,
You have applied for the post of assistant.
I was appointed in the post of assistant library assistant since 2006.
No. At the time of filing application, you have
My lord,
The
they are producing application, that application, according to me, it is a post provincialization recommendation. It is a post provincialization recommendation. My lord, here the page 68, there is no date mentioned when I have submitted this. This is and it was attested on 6/3/23, long after the provincialization.
Hmm.
It is a post provincialization document, my lord. And my submission is that even I have applied for that post, but I could not be considered according to them because of the lack of qualification. Then why I could not be considered in the post of library assistant? And in that case, there would have been no violation of law, but his case has been considered violating the law. That is my submission, my lord. And no provincialization can be considered in violation of the statutory law. And in the previous proceeding, the Honorable Court has advised to go for other vacant post of library junior assistant. And accordingly, I agreed, and accordingly it was remanded back for consideration of that post. But it was not considered, rejected. And he has been, I have not, in the earlier proceeding, my challenge was his appointment on the same ground. My challenge was on the same ground. And therefore, there was a hearing. If Lordship wants to see my earlier petition, that can be tagged and seen, my lord.
So just is it available? Can you produce it? Or Mr. Sikar, Learned Counsel for the petition. Mr. Abedin for respondent number 7.
Yes, my lord.
You for? Okay, okay. And Mr. Das for respondent in higher education department. Argument concluded. Mr. Das, Learned Counsel for the respondent in higher education department has produced as 11.5. But it appears that the resolution of the SLC by which the respondent number 7 is recommended or being posted as library assistant is not available in the file. Accordingly, Mr. Das is directed to produce the resolution of the SLC before this board or when? After 1 week? After 1 week.
My lord,
Argument concluded only for protection of that.
only one thing I would like to say, my lord, what my
No,
friend,
no.
what, it's simple law point.
Hmm.
What my friend referred to, that section 4 of 2017 Act
Hmm.
is not applicable because that is for teacher.
No, you have already submitted.
Yes.
The ministerial rule is applicable.
Yes, my lord, would your lordship be pleased to see that ministerial rule which is applicable?
We will furnish it to court master.
Yes, ma'am.
My lord.
Standing items, 1 and
My lord, in 2018 rule is also there, my lord. Hmm? How?
Next Tuesday.
Standing 1 and 2.
My lord, may I draw my lordship's attention to the last order, my lord, of passed on 22/9/2025.
Yes.
Lord, no affidavit has yet been filed and our arrear salary has not yet been paid, my lord. Only the current, my lord, admittedly we are receiving, no? Print out will one.
Going for elementary education department.
Mr.
Okay. Elementary.
Raj.
Just before he was.
Over.
Elementary. Okay. Department. itu section of what I speak. Plastic to yes, I think net plastic to 29.
My lord, a communication has also been, my lord, produced on the last occasion, which is a part of the record, my lordship's, my lord, which says that this sanction has been accorded for the area amount.
Hmm.
But my lord, it is in the, not at the finalized and no amount has yet, till date has been disbursed, my lord.
Hmm.
The order has not been fully complied with, my lord. The order passed by my lordships also, my lord, directing them to pay the arrear. Instruction to exit को आहे बोला है.
It is kind of okay. Mr. Moya, after some time, let the
Mal.
council.
Mal.
Item 4 and 5.
My lord, in my written argument, there is a one type mistake, my lord. I want to give a corrected written argument, my lord. Just one thing, my lord.
Okay.
And I may be allowed to take back that one, my lord.
5.
May village lordship. My lord, first kindly take the matter Solimuddin. Item
Some
4.
about the council for the elementary education department is not present. Wait for some time.
My lord, in this matter, in the second case, my lord, we had received some instruction, my lord, it is not adequate, my lord. So I have written to the department, my lord. They are processing, my lord, they will send the paralyzed instruction.
Pardon?
They will send instructions, my lord, adequate instruction.
Kindly see the orders, last orders, various orders. Since 2006, even after provincialization, my salary is not paid.
And my lord, one more thing, my lord. In the second case, my lord, Hafizur Rahman,
Yes,
in that case, my lord, we have received, on the last occasion, Mr.
Yes.
Salma was there, he has faced it, my lord. The petitioner has been accommodated as a tutor, so that development was there.
Hmm.
So that is why the, we need the full instruction, my lord. Because since he has been accommodated as a tutor, that is why, my lord.
No, in the first case,
first case since 2006. 31, 2006, I have been provincialized by the director. My post has been provincialized. Actually, I was appointed in the year 1994. Only 3 months salaries I got. Thereafter, the matter was thoroughly inquired, cases after cases, and finally, the director passed order on 31, 2006 that that is so many persons posts were provincialized, among including me. But since then also, the item number 4 Solimuddin has got nothing. But in item number 4 Hafizur Rahman, he is getting salary of a tutor from November 21. But provincialization order is on the same day Same order, same officer. My lord,
Lordship will give some
Yes.
time, my lord, because my lord, in between that development was there. Lordship is one of the orders. This thing was accommodated. That's for my lord. Further instruction is required. It is not adequate. My lord. So that is why my lord, Mr. Singh had written, my lord. So I am awaiting that instruction, my lord. My lord, 10 days time may be given, my lord. I will ensure that if not now,
So many times they are taking unnecessarily.
in between, my lord,
In the name of instruction, affidavit,
my lord, on the last occasion we had produced.
2006, I am not paid. How I am running my life with my family? Kindly consider. At least current salary may be paid. My contemporary Hafizur Rahman has been paid. So like him, current salaries may be paid.
Let
Let
my lord, instructions come, my lord. We'll, my lord, that will be necessary for the proper adjudication, my lord. That instruction will be necessary, my lord. Because we have given on the last occasion, my lord.
But
Not that,
if
not,
one person is given the salary, why he has
no,
not?
no, man, that is what, my lord. That is why the scrutiny is there. That is why they're scrutinizing it, and my lord, they will send the up-to-date instruction. Because without the up-to-date instruction, my lord, it will be
Mr. Fukan,
difficult, my lord.
you see, this petition was of 2015.
My lord. There are two petitions, my lord. One is 15, one is 17. Rightly or wrongly, my lord, there has been developments in this case, my lord. And my lord, that is why, my lord, I'm checking 10 days, my lord, just 10 days. Because then, my lord, the actual update I'll get. Because today I'm handicapped, my lord, because I don't have the proper instruction, my lord. 10 days will be given, my lord, fixed date may be given. By that time, I may be allowed to bring the instructions on record. That will be sufficient.
instruction, what
But it
instruction?
appears that you have taken several dates for obtaining instruction.
No, my lord, if your lordship sees in the other order, my lord, on this thing, it is on the second case, the instruction was given, my lord, regarding the Hafizur. But in the case of the other case, my lord, that case, the main instruction is required. It will be essential. I'll get it, my lord. I'll file my affidavit if required. At least, my lord, give me 10 days, my lord. That's the last time.
Or Mr. Mahmood learned from the court of petition. So Fukan learned something from the court responded elementary to the court. Mr. Fukan submits that an account of some recent development, further instruction is required and he tries to grant it in 2 weeks' time. However, considering all the facts and circumstances and especially considering the fact that the matter is pending since the year 2015, Mr. Fukan is granted 10 days time as last sentence. In the event of failing to obtain necessary instruction, the court will proceed to hear and dispose of this petition without the instruction of Mr. Fukan. This is the matter on
17,
1/7.
November.
Well, let me pray one thing. Part had kindly keep it part had against
Rest of
2000.
My lord.
Coming items 1 and 2. 1 and 2.
Rupale. Rupale বলতে পারবে।
Mr. Fukan, where is your affidavit?
Or not?
keep in this, like this.
একটা কপি মুকুল দিয়ে দিবা এবার খোয়া
The instructions have come, my lord. I have sent the instructions.
But where is your affidavit?
Lordship, the instructions have come regarding the thing, my lord, because Lordship goes to the instructions, your lordship will come to know. My lord, if I may, allow be allowed to read it first. That the budget of for payment of arrear salary had been allotted by letter under reference as per the government sanction letter number so and so dated so and so for the periods with effect from December 23 to February 25 amounting to rupees 9,18,726 in respect of Sariful Islam. The petitioner in the said case, in this connection, mention is made that the honorable so and so, my lord, and my lord, already the sanction has been issued. Yes, come.
স্যাংশন তো লাস্ট টাইমে এসে করেছে মুখ কথা দিয়েছে না হোয়াটসঅ্যাপ আমার দিয়েছে তোমার কিমান তারিখ হবে
Third of November. Third of November.
3rd of November.
This is 3rd of November. So dated.
This is 7th of November 2023.
3rd of November. It's a letter from the joint director.
No, this is the letter of director.
My lord, this is issued from the joint director, my lord, to the senior standing council education department.
I've given him a copy.
My lord, status of allotment of budget for payment of arrear salary, my lord, to Sariful Islam. My lord, this on the last occasion, my lord, in the month of September, they have produced a letter from which, my lord, it reflects that, my lord, the for the purpose of payment, my lord, it has been sent to the accountant general's office, my lord, AG. Letter.
It's pending there, man.
Now, thereafter, my lord, what happened, we don't know, but the similar communication has again been made, my lord. If, my lord, that is a part of the record before the, my lord, before my lordships, my lord, this is a letter dated 20/09/2025, my lord. Which says, my lord, that the sanction of rupees 9,18,000 has been, my lord, accorded and the matter has been sent to the accountant general Assam Moidamgaon Beltola.
And my lord, if your lordship says, sees the second page of the instruction which I have given, my lord. There, my lord, the form B2, the budget allotment has been made, man. 9,18,726.
The palm gate.
That is the question. In the process.
Which
My lord, it's in the right track, my lord, because the budget allotment has come, that means it's in the right track. Had this not been there, then he can say, my lord. When they will get, we don't know, but they'll get it, my lord. Very soon they'll get, because the budget allotment has come, second page. I've given him a copy also.
পয়সাটা দিয়ে দিয়া না
No,
So, I will do, no? Accountant General of Rights.
on 22nd of September 2025, one letter was produced.
Yes, my lord, that has been mentioned here, my lord. In this letter only, they have mentioned here that as per sanction letter dated 29/25, based on that letter, my lord, this letter has been given. This and as well as the budget allotment. And the amount also has been given them, which he has claimed. 9,18,750. Sometime may be given, my lord. Sometime may be given, by that time maybe the amount will be received, ma'am. 3 weeks time may be given, ma'am. And may be kept pending, ma'am.
Well, it appears that they are proceeding, my lord.
We are proceeding, ma'am.
They are proceeding.
Not
my
that
lord.
it is stagnant, ma'am.
My lord, and as my lord, by their mercy, my lord, and I am receiving the current salary for my
And
survival.
my lord, for that current salary, I would like to produce this.
No, no, I am pious, it is not
No, no,
disputed.
but still, my lord, for the lordship perusal, my lord. The last page, my lord, the current salaries also have been paid.
Art, Mr. Bhuya, Lord.
My lord, I on behalf of respondent number 7 and 8.
Look like a
Like
first
to
idea.
submit before your lordship
Huh?
that
Amount of-
we are 7 and 8 is senior person getting no benefit from the government. Till date, despite we have rendered service for more than 20 years. So my learned friend, Mr. Pokon, should file an affidavit. Why government has not considered our case and why our service has not been regularized and why we are not getting any service pay. Kindly an affidavit is solicited from the government side for my clarification. Otherwise, I am in very awkward position. We are in trouble to maintain our life. That's why we have rendered more than 20 years of service. That is why I am, but that may be kindly my affidavit could be revised.
So when you are going to file your affidavit,
My lord, in this case, my lord, we have, we'll file, my lord. Till now, I have not received any instruction, my lord, regarding that aspect, my lord. We'll file it with, the other state. The next,
My lord, affidavit in the main writ petition, my lord, regarding the challenge of the impugn order. Their stand is very much required, my lord, because we have challenged the impugn order and that impugn order has been stayed by this honorable court. And due to the operation of the interim order, all these subsequent developments, my lord. Now, therefore, my lord, for final adjudication, affidavit is required. If they are not filed, then my lord can hear without their affidavit also, my lord, can decide the issue, my lord.
also heard some Pokon, Lord, I think also for the respondent for the elementary education department. That Mr. Khan for respondent number 7 and 8. You are for 7 and 8.
My lord, I am for 7 and 8.
And Madam for respondent number 3, Ms. Borough for respondent number. You do not know.
Complete position. Finance is respondent 10, my lord. Finance is respondent number 10. Later on, they have been impleted.
Number 10. During the course of hearing, Mr. Cooper learned the text counsel for the respondent in elementary education department has produced some letters. And on the basis of the said letters of the joint director of elementary education, Mr. Cooper submits that the process for payment of the area amount of rupees, area salary of the petitioner amounting rupees 9,18,726 is going on, and he price for listing the matter after 3 weeks. And in the meantime, he will ensure payment of the aforementioned amount to the petitioner. Mr. Pokon also submits that he may be granted some time to file the affidavit. They are allowed, based on matter after 3 weeks. In the event of failing to file the affidavit in opposition, the court will proceed to hear and dispose of the petition without the affidavit of the
Mal.
respondents in elementary education department. The communication produced before the court today shall be taken to the record by marking the same as annexer that
Mal. Obliged, deeply obliged. my lord.
Item number 7.
it is over.
May I please? The matter regarding proposition of service Miller. In this case, after first round of litigation, the government to consider the case of the petitioner. And finally, the state level scrutiny committee submitted the name of the petitioner along with others to provide provincialization. That is page 44. Page 44 and extra 15 million. After the earlier read of round of litigation, that is serial number 2, WC number 7274, filed by Shariful Islam. Then the name of the petitioner at serial number 2, my lord. It is recommended on, my lord, 9th of August 2024, but till date, my lord, the, my lord, service of the petitioner has not been provisioned.
Pardon?
Till date, it is a, my lord, the recommendation of the state level scrutiny committee.
Hmm.
It is on, my lord, 9th August 2024. But till date, my lord, the provisionalization has not been done by the government. It is my case, my lord. And one last occasion, my lord, it was directed to, my lord, submit the, my lord, up-to-date
Yes,
status
Mr.
report.
U. Sharma, for secondary education department.
My lord, after recommendation of SLFC,
Hmm.
and a state level committee in its meeting held on 7/6/2024 had recommended the name of petitioner for provincialization of service second post of assistant teacher in the said school. Accordingly, my lord, said proposal has been submitted to the government also, my lord. Here it is stated accordingly. I have latest instruction regarding this matter. Accordingly, proposal for creation of 8 posts for provincialization to teaching staff of various high and senior secondary school, including the name of petitioner, has been sent to the government head office letter number so and so. Accordingly, the matter was placed before the joint committee for provincialization in its meeting dated 28/2/2025, and it was found that the name of the incumbent was not included in UDI's data from 2014-2016, and accordingly, the committee decided to verify from all angles, taking into consideration the subject-wise enrollment of each class, also to cause a physical verification of the attendance register of the concerned school of the incumbent. Thereafter, this office by letter number so and so dated 21/8/2025 has directed the inspector of school GDC Gwalpara to submit the original attendance register of Kahibari High School, District Gwalpara for academic years 2009-10 and 2002-2016-17. Thereafter, inspector of school GDC Gwalpara by letter number so and so dated 10th September 2025 submitted the attendance register of the Kahibari High School, District Gwalpara for academic years 2009-10 to 2016-17. Upon physical verification of the attendance register for the period of 2009-10 to 2016-17, it has been observed that the incumbent's name does not appear in the common attendance register maintained during the said period. However, a separate attendance register has been maintained only for the incumbent without any justification. The genuineness of this separate register is doubtful. No justification is provided to maintain a separate attendance register for Muhammad Shariful Islam. In fact, there is no necessity to maintain separate register without any resolution of SMDC of school concern. Therefore, there is a doubt about his continuous attendance in his school for the academic session from 2009-10 to 2016-17. Apart from attendance maintained in the digital platform against the aforesaid school has not been met so far the presence of Muhammad Shariful Islam is concerned. Moreover, the office by letter number so and so dated 21/8/2025 had requested the Secretary, Assam State School Education Board, Division 1, to provide the number of students appeared and pass percentage of HSLC final examination of Kahibari High School, Gwalpara district, in which the incumbent is serving during the academic year 2014, 15, and 16, which is still awaited. So, my lord, a letter has written to the,
No, Mr. Sharma,
my lord.
whether in the Act of 2017, there is provision for joint committee?
My lord, for verification of whether his attendance or he was
No,
present.
whether the district level committee and the state level committee has not verified the attendance of the petitioner at the time of recommendation of his name?
My lord, here, my lord, verification for every angle. So that it is clearly come out that the petitioner attendance was there at that
No,
time.
You first tell me whether the district level committee has not verified the attendance register of the school.
It is similar the page 24, the district level institutional committee's report at page 25
Hmm.
and 26. There is very much there, my lord. Only case is that, my lord, three science teacher and two posts has to be, my lord, provincialized. One, my lord, resigned, that is, my lord, Pradeep Kumar Das. Subsequently, he died. Then my name was, my lord, recommended by the, my lord, the district level scrutiny committee. Thereafter, when the provincialization comes, my lord, name of the, my lord, Pradeep Kumar Das included in the provincialization order.
Why separate attendance register is maintained only for the petitioner?
No, it is their submission. I don't know, my lord. I have no instruction whether, my lord, it is separate, my lord, attendance register or, my
You
lord.
do one thing, Mr. Sharma, you furnish a copy to him.
Yes,
of
that's
this
it.
letter.
Then
Let him obtain instruction. Then
I have no
you
such
also
instruction,
from
sir.
your, no, from the concern act, you show me the provision where this joint committee is constituted, under which provision it was constituted.
Special committee. That is-
But Mr. Kayu, for the petitioner, sir. You saw no learned something council for the respondent, the higher secretary department. During the course of
এটা কবি আছে নাকি আপনার কাছে?
deliberation, Mr. Sharma has produced one letter of the Director of Secondary Education dated
এটা কবি দিয়ে দিব আমার? Thank you.
17th and 2025 and submits that after recommendation of the name of the petitioner by the state level committee, the proposal for creation of 8 numbers of posts for provincialization of service officers staff of various high school and senior secondary schools, including the name of the petitioner, has been sent to the government by letter dated 8/9/2024. Thereafter, the matter was placed before the Joint Committee for Provincialization in its meeting held on 28/2/2025, and it was found that the name of the incumbent was not included in UDICE data from 2014 till 2016. And accordingly, the committee has decided to verify from all angles, taking into consideration the subject-wise enrollment of each class, also to cause a physical verification of the attendance register of the concerned school of the incumbent. Thereafter, a letter dated 21/8/2025. No, letter dated 21/8/2025. The inspector of school, DDC Gwalpara, was directed to submit the original attendance register of Kahibari High School, District Gwalpara, for the academic year 2009/2010 and 2016 to 2016/2017. And thereafter, the inspector of school, DDC Gwalpara, has, by this letter dated 10th of September 2025, submitted the attendance register of the Kahibari High School for the aforementioned period, and upon physical verification of the attendance register for the period of 2009/2010 to 2016/2017, it has been found that the name of the incumbent does not appear in the common attendance register during the said period. However, a separate attendance register has been maintained only for the incumbent without any justification, and the genuineness of the said separate register is found to be doubtful. And apart from the attendance maintained in the digital platform against the efforts, the school has not been matched so for the presence of the present petitioner is concerned. And thereafter, by letter dated 21/8/2025, the Secretary Assam State School Education Board Division 1 was requested to provide the number of students appeared and passed in the SSLC final examination of Kahibari High School, Goalpara, in which the incumbent is serving during the academic year 2014, 15, and 16. And the same is still awaited. And on such count, Mr. Sorma submits that the matter may be listed after some time so that the aforementioned information can be obtained. Where is accordingly allowed, let a copy of the order, a copy of this letter be furnished to Mr. Kayum Learned Council for the petitioner's wish to obtain him necessary inspection in respect of maintaining true attendance registered in the school for the period 2009-10 to 2016-2017 in respect of the petitioner. This is the matter after 3 weeks. After
Your Lordship,
the
may kindly-
letter produced before the court today shall be marked as an XRP that we take with the record.
Lordship, maybe taken as my part matter, since my.
Okay.
Hmm.
Principal list of matter is part. We will resume after 5 minutes.
Well.
My lord, petitioner was serving as a grade 4 employee of Thonsiri High School under Karbi Anglong district, my lord. And he has retired from service on 31/10/2022. And thereafter, my lord, the authorities have released all the benefits, including provisional pension. And page 22, the proposal was submitted before the office of the Director of Pension. And Director of Pension has stated that High Annexure 5, page 22, that there are some excess dwell. And therefore it was, the pension proposal was returned back. Now, my lord, the Karbi Anglong Autonomous Council has filed the affidavit stating that the matter is under process and the petitioner is required to sign the certain documents and required to furnish the documents such as passport size photograph and bank account details. So in that line, my lord, matter may be disposed of, directing the authorities to finalize the pension. I will submit my passport size photograph as well as bank details within a time frame, my lord, if my senior parent agrees. Paragraph 6 and 7 of their affidavit. Page 26 and 27.
When you have retired from service,
My lord, on 31/10/2022. 31st October 2022. And necessary proposal was submitted. Page 17 dated 29/5/2023. then pension department return.
The question is whether the respondents are entitled to recover this amount. In
Can-
view of the decision of Supreme Court in Rafiq Masjid's case.
Regarding my lord, recovery of the amount has not yet come, my lord.
Yeah.
As the my lord pension, after my lord,
No, your affidavit says so that sum of rupees 2,90,000.
my lord, we have, that is the excess amount he has drawn, but in the affidavit, we have not stated that the amount is recoverable. That has, statement has not been made. Our statement today is that, my lord, our affidavit, that the pension paper of the petitioner is required to be processed after fixation of the pay, my lord, which was earlier erroneously done. So, my lord, after submitting the required document, we will send the pension proposal to the director of pension, then the authority will take the decision whether the amount is recoverable or not. Document is there, my lord, it cannot be recovered, so that decision will be taken by the
Yes.
director of pension, not by us, my lord. If that decision has not been taken, my lord, so he will get the pension. So we have not stated in our affidavit that this first amount is recoverable from the.
There is also no
Only the my lord
notice.
pension paper, he has to submit the required documents and we will send the pension proposal to the. He has to sign the document, submit the passport size photo, bank details, so we will send it to the government side, that's the section. And if the authority has decided to, my lord, pass any order recovering recovery, my lord, that can be silenced, my lord, that has been decided by the Supreme Court. my
No,
lord.
no, again, then again,
My lord.
under litigation.
My lord, that, regarding that matter, that point has not yet been decided by the authority that amount will be recoverable from the people. My lord, after sending the pension proposal, the director of pension only take the decision on that. So there is a wrong calculation. If the wrong calculation is not on the part of the petitioner, it is on the part of the authority, then it cannot be recovered. That is the law,
No, who fixed the, who made the fixation?
my lord. Earlier fixation was erroneously done, my lord.
No, no,
So
who
the-
done it?
On district council.
My lord, inspector of schools, my lord, that is
Inspector of
the,
Whether
is
the
22,
petitioner, whether the petitioner has any role in fixation
No.
of his pay?
my lord, that is required to, that point only, that final point is there in the judgment. If it is on the fault on the part of the, for any misrepresentation,
No,
then
no.
it can be recovered,
Question is who fixed it?
my lord.
I am a grateful
My
employee.
lord, I'm a grateful employee, my lord. So that point has not yet come, my lord, the recovery part, my lord. Only the process of pension paper at this stage. And the page 22 is clear that the pay of the retiree on so and so should be so and so date. Accordingly, we have fixed the pay and we'll send the proposal, my lord.
Heard Mr. M. Sarma, learned counsel for the petition. This would be a subject object for the rest. Survey and no photo of this object. Being respondent number 1, 2. You were not representing one.
No, my lord.
Mr. Yeah, Mr. You Sarma for respondent number 1
And
and
for
2.
3 only.
Mr. De Sophia learned the tech counsel for the respondent number 3. You for? Respondent number 3. Who is for director of pension? Deuri?
Bitupon Deuri.
Tata case for the respondent number 4 and 5. Mr. Deuri, you are for respondent number 5 and 6 here?
4 and 5, my lord.
4 and 5, okay.
Yes, sir.
4 and 5. Mr. Deuri, for 4 and 5. So why not? Mr. Sarma, learned counsel for the petitioner submits that the petitioner retired on superannuation on 31st of October 2022 as grade 4 employee from Dhansiri High School, Karbi Anglong. And after retirement, the authorities have released his DIS gratuity and provisional pension at the rate of rupees 80,295 rupees per month. By order dated 16/3/2023 till the final PPO is sanctioned. Thereafter, the inspector of school Karbi Anglong District Circle by letter dated 29/5/2023 submitted the pension proposal of the petitioner before the director of pension for finalization. But the said proposal was returned to the inspector of school, Karbi Anglong, stating that the retiree on 1/1/1996 stating that the pay of the retiree on 1/1/1996 should have been 2,650 instead of 2,690. And such clarification was sought for from the head of the department. Mr. Sarma further submits that the petitioner has not misrepresented before the authorities or committed any fraud while drawing the monthly salary, and he is not aware of the payment received by him was in excess, and that the action of the respondent authorities in not finalizing his pension on the ground of excess withdrawal is arbitrary and unreasonable, and as such, the same is liable to be interfered with. Mr. Sarma further submits that the respondent number 3, the inspector of the school has filed the affidavit in opposition, wherein in para number 6 and 7, the respondent number 3 has taken a step that the pension paper of the petitioner was submitted to the director of pension on 29/5/2023, but the pension paper along with the service book was returned by the Directorate of Pension Assam due to wrong dictation of pay during 1/1/1996, and thereafter due verification of service book. It has been found that the fixation of pay at rupees 2,690 as on 1/1/1996 was erroneous due to incorrect calculation, whereas the fixation should have been rupees 2,650. Then at that time, at the time of retirement, the pay of the petitioner should have been rupees 33,470 instead of 36,570. And the excess amount drawn by the petitioner is rupees 2,92,372. And that the deponent, and that the fixation of pay of the petitioner at rupees 33,470 was carried out as a matter of financial property and not by way of PPT. And that the pension paper of the petitioner is in process, and the petitioner is required to sign certain documents and required to furnish the documents such as passport size photograph and bank account details. Mr. Sarma further submits that the petitioner is willing to sign the documents, and also he will furnish the passport size photograph and bank account details. And in view of the stand taken by the respondent number 3 in paragraph number 6 and 7, his petition may be disposed of by directing the respondent number 3 and also the other respondent, especially respondent number 4 and 5, to settle the pension paper of the petitioner as expeditiously as possible. Mr. Jayasuriya, learned standing counsel for the respondent. Respondent number 3 also submits that this petition may be disposed of by directing the petitioner to sign the documents, and also by directing him to furnish the documents as required in paragraph number 7 of the writ petition. No, sorry, in the affidavit in opposition. Accordingly, taking note of the submission of learned counsel for both the parties, this court is inclined to dispose of this petition by directing the petitioner to sign the necessary documents and to furnish the documents such as passport size photograph and bank account details to the respondent number 3 within a period of 1 week from today.
10 days or 15 days within
15 days from today. And on such document being furnished, the respondent number 3 shall process the same as expeditiously as possible, and thereafter forward the same to the respondent number 4 and 5. And on such proposal being received from the respondent number 3, the respondent number 4 and 5 shall process the same and complete the entire process within a period of 3 months from the
Yes.
date of receipt of the proposal from the respondent number 3. Respondent number 3. It is further provided that in the further provided that in respect of the excess royal log amount, while dealing with the same, the respondent authority, especially respondent number 4 and 5, shall keep in mind the direction issued by the Honorable Supreme Court in the case of Rafik Masis, related quite well versus State of Punjab. People paid its in terms of above this circumstance, disposal.
Deeply obliged.
Item number 9.
We please your lordship. Lordship, this matter may kindly be taken up after some time. My senior Miss Bivnia will appear.
The other day also, Malad, this matter could not be taken up due to her absence.
Not praying for adjournment.
Simple issue, Malad, that relates to suspension. Prisoner is under suspension for more than 6 months.
Who will appear?
Miss Bivnia will appear, madam. She is on legs. After some.
Okay. Wait for the-
Items for admission, item number 27 by VC mode.
I'm sorry, Milord, I made it a small accident yesterday, last evening, and not in a position to move. Am I audible to your lordship?
Mr. Somoa, you are not in the court?
No, my lord, I made it an accident last evening and
Okay.
received some injuries on leg, my lord. That is why I cannot move
Okay,
today.
okay.
Am I audible to your lordship? My lord?
Yes, yes, but the volume is too low.
That may be, there may be a
last
problem
edition,
in that side.
UGC.
I'm hearing your lordship, my lord.
Yes,
My lord, which item 27, my lord?
Yes, yes, 27, 27.
UGC. Yesterday, my lord, the lordship was asked, my lord, regarding UGC to remain present. My lord.
My lord, I'm present.
Oh, yes, yes. But the Guwahati University, my lord, do not have the microbiology department, my lord, microbiology department. I have got the list of departments of the Guwahati University, my lord.
Hmm.
I'm giving. Last.
Who is the director of higher education?
Education. Education is not the party, second edition, my lord.
Okay, secondary education, Mr. Salman. Mr. Samua, yesterday there was a discussion in respect of constitution of a committee,
My lord.
and there is also suggestion to incorporate the expert from UGC. Whether such experts are available in Guwahati?
Guwahati, my lord, definitely there will be a resource person, but I have to take instructions who is the perfect person, right person to be employed in this for this work. Because if it is a subject expert, then my lord,
Yes.
because I don't have a name in my hand. If your lordship give me 1 or 2 day time, my lord, I will come back.
Okay, okay. Then you obtain instruction and let this court know.
My lord, if lordship passes an order, it may be it is helpful for me, my lord.
Okay, okay. Heard Mr. P. Purkeso, Learned Counsel for the Petition. Mr. U. Sharma, Learned Standing Counsel for the Respondent Team Secretary Education Department. Mr. A. Somua, Learned Standing Counsel for the Respondent Team UGC. And Ms. Upaidhya for Upaidhya, Learned Counsel appearing on behalf of Mr. S.C. Kayal, Learned Standing Counsel for the Assam University. After hearing learned counsel of both the parties, it is provided that Mr. Somua, Learned Standing Counsel for the UGC, shall inform this court on next Monday
Yes, yes, my lord.
regarding availability of subject expert in respect of
Microbiology.
microbiology, in respect of the microbiology subject in Guwahati. And thereafter, the court will consider constitution of a committee to examine the issue raised in this petition. List on Monday.
10th
November.
My lord, can it be on
That's
11th of
Spartan.
November, my lord?
Mr. Somua?
Can it be on 11th of November, my lord?
Okay, 11.
I'm obliged, my lord. I'm obliged.
Items for orders, item number 11.
Last occasion, some instruction was
Here, so if the education department has to forward and get the necessary approval from the highest of authority, lordship. Upon that, lordship, we can initiate the process.
Hmm.
Now they have directly sent us a proposal because of which it cannot be considered, lordship.
Because there is order of the court.
Yeah, Lordship, that we are not disputing it, Lordship,
Then-
but it has to come through the right channel, Lordship, and now they have directly approved. So let them place it in front of the highest of authorities, Lordship, from there, once the approval, Lordship will take their time. Now they are sending it to us, Lordship, here, our hands are tied in this case. And therefore, we have, by the endorsement, we have given our views. Lordship.
Sir Bora, are you not aware of about the procedure being followed by the department?
Regarding this particular procedure right now, I'm from him.
I've informed him also, Lordship, and now they just need to they need to put it up in front, Lordship, and once the concurrence is given, it won't take much time. Now, only the right channel has to be followed. That is all my limited submission also.
Heard Mr. Kandakar, Learned Counsel for the petition. Mr. A. Soliha, Learned Standing Counsel to the Finance Department, who remain present before this court as per request made by this court. And Mr. P. K. Bora, Learned Counsel for that contact. Mr. Soliha has produced one letter issued by the Under Secretary to the Dr. Assam Finance SIU Department and submits that while forwarding the proposal for creation of the post in respect of the present petitioner, the contender has not followed the procedure prescribed procedure. And as such, the proposal has been returned. By the endorsement dated 3/11/2025, and as soon as the department has received the proposal through proper channel, then the financial concurrence shall be accorded. And the same will not take much time. And as such, Mr. Soliha submits that the matter may be listed after.
Lordship, 4 weeks time may be given. In the meantime, Lordship, the entire process will take, or maybe 3 weeks time, Lordship, let the education department come up with the.
After 3 weeks. Let a copy of this petition, no, copy of this letter dated 3/11/2025. The Under Secretary to the Governor of Assam Finance SIU Department, the furnished to Mr. Bora, Learned Counsel for the contender to obtain up to date instruction in respect of the process and to apprise this board on next step. This is the matter on
28 November.
28th of.
I'm ready.
Item 12. 12.
Wait, please, allow. They were having some confusion about the name of the petitioner.
To furnish a copy to him.
Well,
You obtain instruction. Your name was not recommended by the TLC.
Name was recommended, your lordship. That is there in the order itself.
No, not recommended.
Recommended by the TLC.
No, not recommended.
No, in the writ petition, we have even furnished the TLC report. If lordship can.
In which paragraph of the order it was observed?
From. In paragraph 17 may make it clear, I think. In 16, your lordship. Subsequent. A perusal of the order dated so and so, read the order dated so and so reflect that initially the name of the petitioner herein, along with 4 other serving teachers in the state school, were recommended by the jurisdictional district scrutiny committee as being eligible for provincial of the services. It is written that thereafter the state proposal was again demanded back to the district scrutiny committee purportedly for resubmission of the same in accordance with the provision of the act. The district scrutiny committee on the matter being remanded back now proceeded to recommend the name of 3 serving teachers in the school. That is the respondent number 6 and 7 and 1 Jyotikar, the science teacher of the state school. It is not understood. Yes, lordship is correct. As to why the name of the petitioner herein was not so recommended for provincial office services. The materials as available on record does not demonstrate that the petitioner herein was not eligible for being considered for provincialization of his services. Further, it is seen that the particulars as submitted, as well as the initial recommendation made in the matter by the jurisdictional district scrutiny committee, it is only the petitioner herein who is teaching the subject of social studies in the state school. I think subsequently they did not recommend his name. But in paragraph 22 of the order, your lordship, it has been categorically held, if I may read to you. In view of the above undisputed position coming on record in the matter and the petitioner herein admittedly being the only teacher teaching the subject of social studies in the school, his service could not have been ignored while provincializing the service of the serving teachers of the school. Accordingly, it is held that the petitioner herein is eligible and is entitled to have his services provincialized as a social studies teacher in the state school in accordance with the provisions of the section 3111 of the State Act. And then there were 2 private respondents. So service of both the private respondents have been interfered with. And it is directed that they should decide as to who among the 2 private respondents should be kept. If paragraph 23, your lordship, having held that the petitioner herein is eligible and entitled to have his services provincialized in the state school as a social studies teacher, it is now to be seen amongst who the respondent number 6 or respondent number 7, whose provincialization is required to be interfered with so as to facilitate the provincialization of services of the petitioner herein.
So
The rival
ultimately,
country,
what was the direction?
lordship,
What was the direction of this court?
direction lordship will find it paragraph, page 27, paragraph number 27. In view of the conclusion as reached and the following directions are being issued, the Director of Elementary Education, Assam, in view of the determination as made herein above, that the petitioner is eligible and entitled for having his services provincialized as a social studies teacher in the state school, would now place the case of the petitioner before the SLSC for the scrutiny of his service particulars, and the Director of Elementary Education, Assam, while placing the case of the petitioner herein before the SLSC, shall intimate the committee that the petitioner is working in the state school as a teacher with effect from so and so, and he admittedly is teaching the subject of social studies in the state school, and in terms of the provision of section 3111 Act of 2017, he is eligible to have his services provincialized in the state school. The state level scrutiny committee on the case of the petitioner being placed before it
shall proceed to scrutinize the service particulars of the petitioner in the light of the determinations made in this order by this court, and thereafter proceed to make its recommendations. The Director of Secondary Education Department, Assam, shall on receipt of the recommendation in respect of the petitioner from the SLSC, proceed to further process the matter, and in the event the said recommendation is in favor of the petitioner, proceed to provincialize the service of the petitioner after following the procedure as mandated under the Act of 2017. In the event the petitioner here is found to be eligible for provincialization of his services, such provincialization in his case shall be so effected with effect from so and so, with all consequential benefits and seniority, etc., etc. The appointments of respondent number 6 and 7 having been interfered by this court only on the ground that the materials on record do not conclusively indicate as to whom amongst them is to be provincialized in their services, the respondent number 6 and 7 are hereby directed to prefer appeals before the Secretary to the Government of Assam Department of School Education, staking their claims for provincialization of their services. The Secretary to the Government of Assam Department of School Education, on receipt of such appeals from the respondent number 6 and 7, shall place the same before the SLSC for further scrutiny of the service particulars. The SLSC, on receipt of such appeals, shall proceed to scrutinize the matter by exercising the power vested in it under Section 1311 of the Act of 2017, and thereafter, upon a detailed examination of the contemporaneous records contained in the school, also by ascertaining the continuous nature of service rendered by the respondent number 6 in the school, ascertain as to who among the respondent number 6 and 7 is eligible to have his or her services provincialized. Basing on the determination that would be now made in the matter by SLSC, the Secretary to Government of Assam Department of School Education shall pass a speaking order directing the provincialization of the person now found eligible amongst the respondent number 6 and 7 for having their services provincialized. It is provided that amongst the respondent number 6 and 7 who is now found eligible for having his or her service provincialized would be entitled to have his or her services provincialized with effect from so and so, with all consequential benefits. So far as the petitioner is concerned, the court has come to a definite conclusion that he is eligible to have his service provincialized. The SLSC to look after the matter and pass a detailed order and do the needful order. And respondent number 6 and 7, they will have to take a call as to among both of them who is to be provincialized. Even though the District Scrutiny Committee did not recommend his name, but the court is of the view that his name could not have been ignored by the District Scrutiny Committee.
Oh, what is the ultimate decision of the SLC?
My lord, but that has to come from the district, my lord. His name has to be recommended by the district, my lord. That's per the rule.
Pardon?
His name of the petitioner has to be recommended by the district authority.
No,
my lord.
no, you come to the last page of the order.
My lord,
So this letter.
my lord. Accordingly, this office obtained a clarification from DO Dhemaji by reference of 24/10/2025. Thereafter, another meeting of the SLSC was held at the office chamber of the DE Assam on 30/10/2020. The SLSC committee resolved that the detailed report with all relevant documents may be submitted to the government in pursuance of a government letter under reference number 1 seeking approval of for placing the matter for reconsideration of its recommendation as per clause 3.1.11 of the Act 2017. The strength of the in the strength of the honorable court order dated 34/24 passed into effect. Like here, my lord, that is why, my lord, this communication is made, my lord, so that the name of the petitioner can be recommended by the DLC district level. Because kindly see the first page, my lord. Only three.
No, no. You tell me what is the recommendation of the SLC?
Recommendation, because his name has not been recommended by the TLC. That is why detail, anything no detail about the petition is available before the SLC.
No, what was the direction issued by this court?
True, my lord, true. But my lord, detail has to be required to recommendation from the TLC, my lord. His name has to be recommended from the TLC. Then his detail will be come out.
That was the argument, your lordship. The honorable court said that if direct DSC did not make a correct determination, the matter is paid before the SLC to see whether the DSC has done it rightly or wrongly. Now, if you say that DSC cannot, if this DSC does not give name, we will not consider, that is not. The SSC is a appellate body. If something is wrong done by the district scrutiny committee, the state level scrutiny committee has to look into it. Now, there are cases that not, since district scrutiny committee has not forwarded, so we cannot give. That argument was not considered by the court. The court said, yes, district scrutiny committee has not given, but we have found it on the basis of the materials available on record that district scrutiny committee ought to have recommended his name. That not being them, it is now for the state level scrutiny committee to do the needful.
So that is why, my lord, this SLC asked to recommend his name as a social science teacher, because kindly see his here only science, English and Assamese teachers were recommended. Social science teacher is not there. So, my lord,
No, you cannot take that extent again in this contempt petition, because that was earlier considered by this court. So now what happened? What is the decision of the SLC?
my lord, here, my lord, this has been asked to place before the DLC, my lord. DLC has this
No,
letter,
he come to last page, what happened there?
my lord, this letter of 3rd November 2025. Recent letter, my lord. 2 weeks time may be granted, my lord. I'll bring up to date instruction regarding DLC.
Hard. Look for learned counsel for the petitioner and Mr. P.K. Bora for the contender. Mr. Bora has produced a letter dated 3rd of November 2025, written by the Director Elementary Education to the Secretary to the Governor of Assam Department of School Education. Communicating the resolution of the SLC committee and the details. No, and he pays for listing the matter after 2 weeks so as to obtain up to the instruction in this letter, in respect of this letter. There is accordingly allowed to list the matter on 10 days. 19. The letter produced before the court today shall be marked as an Annexure B and be taken to the
Obliged.
Items 13 and 14.
In compliance to my lord, the review petition 106/2021 WPC 4729/2021 dated 2/9/2013. An order has been passed by the director and accordingly then direction of director, the inspector also inspector also acted upon it, my lord, and this is my instruction here.
Pension proposal file has been, my lord, forwarded to the Director of Treasuries under Finance Department.
Already, my lord, a area salary proposal to of late Vijay Shankar Thakur has received from the headmaster of the school, right, to the director of school education. It was released. Right? Undersigned has already submitted the area salary proposal of late Vijay Shankar Thakur of ex-headmaster in charge of Srimati Chandraprabha Pandit Smriti Hindi Vidyalaya as they received from the headmaster of the school, right? Office letter number so and so to the director of the secondary education. And further, the inspector of school also submitted the compassionate family pension proposal to the, my lord, director of accounts and treasuries, Assam Dispute. Office and my lord, the inspector of school has also released the service benefits, that is GIS and leave encashment amounts to legal heirs of the late Vijay Shankar Thakur, Vice Srimati Kamala Devi, by this letter number so and so dated 27/7/2022. And my lord, now director received the proposal from the inspector of school, and the matter is verifying by him, and after a proper verification of area salary proposal submitted by the inspector of school SDC Sonitpur, and it is found to be in order, necessary proposal shall be forwarded to the government to comply with the order dated so and so in review petition number 106/2020.
Now, my friend,
My lord, process is going on, my lord. So sometime is required.
the Finance Department is present there, my learned friend in the Finance Department may update in the next.
Regarding director, the proposal sent to the director of accounts and treasury. But if that update I can get to it.
Let it come on Monday, my lord, in that event, like my learned friend may take update instruction from the Director of Treasury,
Monday?
because
Lordship, we'll try at least 1 week time. I'll get the instruction regarding the compassionate family.
Okay. Or Mr. Frucas or the Mr. Sorma or next something of the product number. One and two.
11.
120. And Mr. Soliha for their contact number, number 4. In the course of hearing, Mr. Sarma had produced some communication between the inspector of school and the director of secondary education, and submits that process for compliance of the order of this court dated 27/6/2024 is going on, and he pressed for listing the matter after 1 week.
For director, I'll need 1 week.
On 11th of November, maybe.
The two for 17th. 17th. This is a list the matter on 17th November. In the meantime, Mr. Soliha, that Council for the Contemptor number 4 obtain up to date instruction in respect of the
Compassionate applicant.
compassionate family.
Director of accounts.
Compassionate family. list the matter according the communication. But the letters furnished before the court by Mr. Sharma shall be marked as Annexure A Y, Annexure Y series and shall be tagged with the record.
Item 15.
Hearing will there, 10-11, there will be hearing
When?
on 10-11. Petitioner has to present before the authority members. On 16-10, there was also a hearing, but he did not appear.
Why hearing is necessary? Because there was direction of this court.
Yes, my lord, only for he is appointed as stipendiary teacher or not. That is, if stipendiary teacher, he is eligible for pension.
To verify the record. Here, accordingly, you are requested to bring all readable records from the district authorities. District authority, Shivsagar and Soraigam.
When this order was passed?
Yes, my lord, order was passed on 19/2/2024.
Heard Mr. Polita, heard it come before the petitioner. Sir, PK Pada, heard it come before the Pada has produced a letter. The petitioner has fixed 10/11/2025 for hearing. And in the said hearing, the Director Elementary Education and the District Elementary Education Officer Shivsagar and Secretary Education Officer Soraigam have been asked to remain present with all the documents. And the hearing will be conducted in order to verify the record. And he tries for listing the matter. For 16. This is holiday, 17. 17. The letter produced before the court today shall be marked as Annexure A. No, Annexure X, that shall be taken with the record.
Item 16.
Comply the direction passed by the honorable government. Order has been passed by the secretary.
My lord, in this order, my lord, I have to run through this order, my lord. But only next week fix, my lord.
But my lord, here, my lord, they have, my lord, verified, but as per my lord, Purnima Hore's judgment verified or not, that is the question. Verified, but they have said that I am appointed as excess teacher, my lord. But appointment letter says that I was appointed as secondary teacher. But they have verified that I have appointed as excess teacher.
Okay, you go through the order. You come back after 1 week.
Yes.
Learn Mr. Polito, learn it to put the petition. Okay. So teacher Bora, learn it to put the concept. So Bora has produced compliance order dated 3/11/2025. And perusal of the same indicates that the claim of pension under the Assam Service Certificate Pension Rule 1967 is rejected. Claim of the pension by the Polito submits that he may be granted some time to obtain instruction. There is allowed presence of the matter after 1 week.
17, 19.
The compliance order for the court shall be marked as an extra B. And we take to the
Obliged.
applicant.
My lord, মই কৈ লওঁ নাই মই আজি মই নিদিওঁ জবৰ আপোনালোকে দিয়া মই কৈ লওঁ আপোনালোকে পিছত may it please my lord I have filed this IA for modification of honorable court's order, my lord, dated 22/10/2025, my lord. My lord, may kindly have page 12, my lord. 11 it starts, my lord, and 12 is the relevant part, effective for. My lord, this order was listed as item number 37 on 22/10/2025, my lord. What had happened is that, my lord, when the matter was initially called at around 11:45 AM on that particular date, my lord, the petitioner, my lord, they had sought for some time being, my lord. Thereafter, I was also present at that time, my lord, physically. Thereafter, my lord, we were informed that the matter may be taken up at 2 o'clock. So accordingly, at 2 o'clock I came, but at 12:45, my lord, from the video recordings, it seemed that the learned senior who is arguing this case from the petitioner's side had come and had taken the order. Later on only, my lord, when the orders were sent inside, my lord, at 2 PM I came and I had marked my presence, my lord. That is why I was not aware about the outcome of the order. Although my name is reflected, but I had no knowledge what the personal appearance that was passed by this court, my lord. That is the sum and substance of this order. So, my lord, in a way, it was ex parte, my lord. Because without my presence, it was done. At 2 o'clock, I just recorded my name on behalf of my senior, Mr. M. Sarma. That is my grievance, my lord.
May it your lordship. On that particular day, we haven't approached the, court
Pardon?
of the matter was called up, your lordship. We haven't approached the court for listing the matter on that particular time. It was called up, so we were present in the court.
We were informed that at 2 o'clock the matter would be taken up. That is why we were also doing other.
No, I have remembered that
Yes.
while we call the matter, then no one remained present.
My lord, if my lord also, I'm sorry, my lord. My lord is absolutely my lord. But my lord, if my lord goes to the video also, my lord had also mentioned in my lord's words that the other side is not there. But the learned senior from the petitioner side had stated that the junior was there sometime back. Video is also there, my lord. Video footages are now
There, but what to do?
we were not
order
informed
was
about the
called
order.
and you remain absent.
No, my lord, I was there. Timing was made by them, my lord. Then I had gone because I was informed that at 2 o'clock the matter would be taken up. At 2 o'clock, I had duly appeared, given the slip
Now,
also.
what is your pair here?
My lord, this order may be kindly modified. One more chance may be given. Personal appearance may be struck off, my lord. One date may be given. We'll comply, my lord. We'll file the affidavit and everything that is required. Some time may be given. Because, my lord, this was done without my presence, my lord, and my senior's presence.
I
No, if
apologize,
you-
my
if
lord.
If you remain absent, then should we bring you from
No.
from the place where you stay?
No, my lord, that is not what I meant. I am humbly saying, my lord, that I was there, my lord.
No, but you let them remain present in the court.
My lord, my
On
lord,
fixed day.
my lord, may I kindly, my lord.
No, no.
My lord, then my lord, my senior may appear, my lord, at 2 o'clock, he'll be here, my lord, Mr. M. Sharma. May he argue the matter, my lord. Utar rahi pa wo to. Because my lord, he's the standing counsel. He's actually for the contemners, my lord. I was just representing
Then
him.
why you are appearing?
No, my lord, on that day I had appeared for him, my lord. On his behalf, I had appeared. That is the case, my lord. And it happened because of a stroke of bad luck, my lord.
No, no.
My lord,
We are
at 2
not
o'clock, it may
interested.
be taken kindly. 2 o'clock, my lord. My senior may appear.
Who is M. Sharma?
Full name, Mukesh Sharma, sir. Mukesh Sharma.
Okay.
Deeply obliged, madam.
Obliged.
May, Your Honor.
Yes.
Your Honor, the college I need to save is the College of Aeronautical Engineering, Guwahati, which is the lone college in entire Northeast India, approved by DGCA, Government of India, in the year of 2009. Your Honor, this college runs as per the civil aviation requirement, that is as per EASA, International Civil Aviation Organization, ICAO, mandate. The Government of India approves the institute all over India. I have established in 2009, and as per civil aviation requirement, CAR, the proprietor need to nominate one person as accountable manager. It is like a CEO or executive, a CEO kind of person. So from 2009 onwards, I have nominated my name as accountable manager, which was accepted by the DGCA. And till 2023, I was ill. In fact, that in 2023, I was facing a worse situation in my life. So I have appointed one person as accountable manager. And because I have appointed a person, I got an advice, and that legally I should give a certain agreement or certain declaration so that he can smoothly run. And I executed those agreement, but without taking any benefit out of it. And that person could not obey could not follow the agreement's rule, terms and condition. And he did not perform his duty. He did not conducted the classes since 2025, 20th January 2025. And in the month of April, he suddenly shifted all the students to Odisha. To shift the student to do any modification, he is supposed to apply for location changes, and after approval by the DGCA, he can do that. I have given in writing that he can do that, because in Assam, I was facing a lot of threatening. I personally, as an owner, I supposed to save my institute. As I said, that was my worst time. And police used to visit my college and
do a lot of illegality with the atmosphere of the institute. So that person did not conducted the classes, did not maintain the CR rules and regulations, and due to all this activity, all this illegality, I have removed him from the post of accountable manager. And I have informed the DGCA that I have removed him and I will appoint one suitable person. All these later are documented. Again, after 15 days, I have nominated myself as accountable manager, which has been accepted by the DGCA. When I have been accepted by the DGCA, I have gone to the office and checked all the papers and found there are a lot of illegality. And there were nexus between the DGCA, that respondent, that officer as Falte, and this previous accountable manager. Immediately, I wrote various letters that why you have not monitored, as per CR, you supposed to monitor whether classes are going on or no. It is like a school inspector. So I have given all this later, all are already annexed here. So when he found that it is going against of him, he immediately removed me, which he cannot do that, because it is undisputed fact that institute is founded by me. Institute, it is undisputed that I am the proprietor of that institute. And without my permission, how can he again accept that previous person, which I objected. And then I filed a case. I filed a writ petition. In fact, he was not accepting me. I filed a writ petition. And when he come to know, suddenly he accepted me. I had to withdraw my writ petition. And then when I wrote various letters to him about his illegality and nexus, then he again removed me. So now the matter is like, as a proprietor, I am sole responsible. If something illegality is going on with the institute, any statute will catch me. If college does any illegality, if students are suffering, students may come before any honorable court and sue me because I am the proprietor. Trade license are in my name. That building is also lease, under lease and lease agreement with me. So I am responsible, and DGCA, that as Falte officer, he has done all this illegality with an nexus with this previous accountable manager. And now DGCA's part is, when I filed this, when they have submitted through their affidavit, they said that I have created a lot of nuisance in my college, and that is why they could not conduct the class. Lordship, on previous date, I have shown that when I have nominated that previous person as accountable manager, that letter is annexed as Annexure 6 and page number 162. Lordship may kindly come to page number 162, Annexure 6. May I read this later?
Not necessary.
In this letter, the seal, receiver seal, that diary number of the DGC official is everything mentioned. Letter receipt number, date, the seal is available. But they have fabricated many letters and submitted before this honorable court where there are 4 letters where there are no seal, no such diary number, no such other officer's signature, nothing is available. So all these are fabricated. In that circumstance, so it is a nexus. And Lordship, the college, they said that, the agreement, with the previous organization to save the college, I have made agreement, not the sale deed. Because Lordship, the approval cannot be transferred or cannot be sold out. And they have given me one check to run the institute. I kept with me that check, but that check was also bounced. I have today received a letter from the State Bank of India. May I give it to City Con? Etu did you? I have sent a mail to State Bank of India. Namaskar. Your office is requested to verify check number 045007 dated 29 December 2023 issued by Vidya Bharati Education Trust for an amount of rupees 7 lakhs. You are also requested to issue a certificate if the same check has not been credited in our account number 35891 382029, mentioning the trust name, check number, amount and date. Sincerely, Bikram Hingo Law Court. So they have replied me today at about 11:40 a.m. Dear sir, madam, with reference to the trailing mail, we confirm that there are no credit of amount of rupees 7 lakhs in your account from the period of 28/12/2023 to 31/5/2024. Again, check number 045007 from Vidya Bharati to account of College of Aeronautical Engineering, account number 358913822029, mentioned with maintained with our branch. Also, a check is valid for 3 months from the date of issue and there is no further credit of the amount in account against the said check as on date. This is Shivam Dev, Chief Manager, SBI Guwahati Airport Branch. His mobile number also mentioned. Lordship, so if being the proprietor, sole proprietor, if I cannot run my institute because of nexus of one officer, so it is really pathetic part. And that is why I need the Honorable Court's direction to the DCCA. And the Honorable Court may kindly set aside the order of that is 7/8/2025, 13/8/2025, 13/8/2025. There are 3 letters, the location change and the acceptance of the accountable manager. They have stated in their affidavit that while accepting in para 12, page number 100, their affidavit, that with regard to the statement made in paragraph 10 of the writ petition, the deponent begged to state that in the grievance by the petitioner to DG, that is Director General, the signing of deed of agreement with VBET Gunupur was initially not mentioned, and as higher officer of DGCA headquarters were not fully aware of the situation of grievance of petitioner was initially considered by the DGCA headquarters. Lordship may kindly see, this is their stand, why they have accepted my name as as an accountable manager. So the same officer who accepted the previous accountable manager to whom I have nominated, that person, that letter is also there. The same person is doing all this thing. It is 24/7/2025. 24/7/2025. Shyam Jumu A.N. Valte, Director of Aberdeenes for DDG Eastern Region, Kolkata, as Valte. So as Valte has accepted my accountable managership, and same person has accepted Sondro Das Panda on 7/8/2025. The same person is doing everything, not any other person. So how can he say that headquarter is unaware about the agreement and all this thing? And one more, when Sondro Das Panda was accepted as accountable manager, as per my request, it was in 1st April 2024. It is at page number 48. Lordship, page number 48, the same as Falte. So this as Falte is doing everything, and he is acting like a proprietor of this college, subsiding me. I am no one. I did not sell my college. I have just handed over the approval letters and documents. I have given them authority to run. I have given my power to them to run it. But when I myself have written to the DGCA headquarters, the same officer as Valte and other senior officer, that they are not maintaining, I have withdrawn them. I have withdrawn all the post holder. They are not listening to me. Where will I go? And the college is now, it is illegal, entirely illegal. The DGCA headquarters has given authority, I don't know, the affidavit said, and the ministry's affidavit also has been submitted, where ministry has not submitted their affidavit, that one officer, the same officer has submitted. In fact, no authority letter is also annexed. This way, DGCA, if DGCA is running, Lordship, it is very dangerous for the aviation industry. And the same person against the as Falte, same person, there are a lot of allegations all over India, and he was there in Ahmedabad air crash. So these are many things.
Yes, what is your case?
I have filed my affidavit for exponent number 1. This is the authority letter, Your Lordship.
Authority letter regarding?
Regarding authorized by DGCA to sign for petition respondent number 1. Oh, fine. Type of letter. Oh, no. Mobile address.
চাব লাগিব তাত কি কোনে বনালে কি তেওঁৰ লগত সাথী
They are just formal party. And in her affidavit, Your Lordship, in page number 94, Your Lordship, paragraph number 5.
Page number?
Page number 94.
Yes.
Paragraph number 5, Your Lordship, from second paragraph. There, I'm reading, Your Lordship. There were numbers of complaints received from management of the organization as well as from students, wherein it was informed that Mr. Vikram Sinha Lawkar creating troubles and problems to run the course and harassing the management team of the institute. And accordingly, I have annexure number 1. Those are complaints, Your Lordship, 1, 2, and 3. Those are annexures. And again in paragraph number 6, Your Lordship, that is from second paragraph, the petitioner had applied for acceptance of new accountable managers on 5/3/2024, wherein he declared that he has delegated financial and corporate power of CAE Guwahati to Dr. Chandradhas Panda so that he can run this college. In this connection, he attached a declaration signed on the 2nd March 2024 before Notary Public Kamrup. And I have annexed it as annexure number 6, Your Lordship. And paragraph number 7, that with regard to the statement made in paragraph number 5 of the writ petition, the deponent begs to state that DGCA had not advised, suggested for any agreement with the Vidyabharati Educational Trust, Gunupur, Orissa. The petitioner himself suggested for such to run the institute due to ill health of the petitioner. Accordingly, Sri Vikram Sinha Lawkar had signed the deed of agreement, deed of declaration, acknowledgement, and declaration with Dr. Chandradhas Panda, Secretary of Vidyabharati Educational Trust, Gunupur, Orissa, to hand over the approval, required facilities, infrastructures, and manpower of the College of Aeronautical Engineering, Guwahati, for difficulty in running the same due to his ill health conditions. The deed of agreement at page number 4, para 3, page number 42 of the writ petition, Sri Vikram Sinha Lawkar clearly mentioned that on the strength of this deed, may create established DIETU College of Aeronautical Engineering with a new aeronautical accountable manager to be nominated by the first party, that is by the petitioner, and the first party shall have no claim whatsoever on the said business with effect from complete execution. And henceforth, the first party is no way liable responsible for the affairs in connection with the College of Aeronautical Engineering, AME part. In the deed of agreement at page number 5, para 4, page number 42 of the writ petition, it is clearly mentioned that the first party, Sri Vikram Sinha Lawkar, having full right to hand over the approval granted by DGCA hereby handed over to the second party, Vidya Bharati Educational Trust, and will not at any time hereinafter revoke, annul, and make void the aforesaid handing over hereby given to the said second party, or do or execute or knowingly or willingly suffer any act, deed, or thing whereby the said second party may be prevented from having and receiving the said approval or any part thereof to and for his own use and benefit, or by means whereof the said second party shall be injured in the said business. That in the deed of declaration acknowledgement, phase 3, para 1, page number 36 of the writ petition, it is mentioned that in pursuance of the aforesaid agreement and in consideration of the sum of rupees 7 lakhs, which the second party has made to the first party by check bearing number 045007 dated 29/12/23, State Bank of India, Gunupur branch, Orissa. The second party with respect to payment of consideration against handing over of approval license for running the aircraft maintenance engineering college. The first party hereby admits and acknowledges the sufficiency of the consideration price, and mentioned in para 2 that the first party shall have no claim whatsoever on the said business with effect from complete execution, and henceforth the first party is no way liable responsible for the affairs in connection with the College of Aeronautical Engineering AME branch, and also mentioned in para 3 that the first party shall hand over all of his powers and privileges on aircraft maintenance engineering of College of Aeronautical Engineering to the second party. It is clear that the first party, Bikram Singha Lohkar, after receipt of the consideration amount in full satisfaction and hand over all of his powers and privileges, approval, licenses for running of the aircraft maintenance engineering college to Vidya Bharati Educational Trust, Gunupur, being represented by Secretary Dr. Chandradas Panda from the date of execution, that is from 2/3/2024 as per T. The copy of appointment letter so and so is there, and that with paragraph number 9, Your Lordship, that with regard to the statement made in paragraph 7 of the writ petition, the deponent begs to state that Office of the DDAW Guwahati has received a letter number so and so dated 9/9/2024, annexure 1 from training manager of CAE, wherein it was informed that Mr. Bikram Singha Lohkar creating troubles and problems to run the course and harassing the management team of the institute. In this regard, he had attached deed of agreement number so and so dated 1/1/3/2024 with Vidya Bharati Educational Trust, Gunupur, Orissa. He stated that as per the agreement, clause number 16, Mr. Bikram Singha Lohkar will not cause any harm with regard to the running of CAE, but he is blocking some of the room in CAE building which are used for AME training purpose. It is there in petition number, writ petition in page number 43, Your Lordship. He further stated that as per clause 7, Mr. Bikram Singha Lohkar has agreed to support in all terms until the change of location of present CAE, where as he is pressurizing and threatening us to change the location by giving us letters mentioning to collect unjustified amounts, to use pictures and building, etc. In this regard, he has attached a letter from Mr. Bikram Singha Lohkar, wherein the petitioner intimated the chairman DIT University for payment of rent for running the institute at Guwahati, and informed that he has done the necessary inspection of the university premises, which is prerequisite for shifting of the AME branch of CAE from Guwahati to Gunupur, Orissa. Further, by letter number so and so dated 29/10/2024, annexure 2, and dated 22/11/2024, Annex 30, the training manager once again intimated Office of the DDAW Guwahati that Vikram Singh Lokar threatened them to change the location of the institute, else he will collect unjustified amount along with interest for utilizing the facility. He also informed that Mr. Lokar has locked the labs and creating troubles to run the course. Mr. Vikram Singh Lokar himself pressurized the management team to shift the student to Gunupur and leave the Guwahati facility. In this connection, copy of letter written by Lokar dated 36/2024. And a copy is annexed as annexed 7 year lordship. And paragraph number 10 year lordship, with regard to the statement made in paragraph 8 of the writ petition, deponent begs to state that CAE Guwahati had applied through EGCA by its application number so and so dated 22/2025 for change of location from Guwahati to Gunupur, Orissa, wherein in the deed of agreement, the two parties for handover of approval and change of location was attached. As there is already agreement signed by two parties before the notary Kamrup for change of location, the Office of the DDAW Guwahati has not considered the request of Mr. Lokar for removal of accountable manager honoring the deed of agreement hereof. That paragraph number 11, your lordship, that with regard to the statement made in paragraph 9 of the writ petition, deponent begs to say that the CAE Guwahati had applied to EGCA for change of location from Guwahati to Gunupur, Orissa, and considering the deed of agreement, the request of the petitioner was not considered. So the petitioner himself creating problems by threatening the management of CAE and locking the rooms used for regular classes. And 12, your lordship, that with regard to the statement made in paragraph 10 of the writ petition, deponent begs to say that in the grievance by the petitioner to DG, the signing of deed of agreement with VBT Gunupur was initially not mentioned, and as higher officers of DGCA headquarters were not fully aware of the situation of grievances of the petitioner was initially considered by DGCA headquarters. That with regard to the statement made in paragraph 11 of the writ petition, the deponent begs to state that on the basis of the grievance from the petitioner, DGCA headquarters initially considered the case and accepted the proposal of change of accountable manager from Dr. Chandradhar Panda to Mr. Lokar, but thereafter the management team of CAE requested DGCA headquarters to reconsider the case as the petitioner violated the agreement signed with Vidyavati Educational Institutional Trust, Gunupur, Orissa. Considering the deed of agreement and reviewing the financial authority of both the parties, DGCA headquarters revoked the order and Dr. Chandradhar Panda has been reappointed as the accountable manager. Paragraph number 15, your lordship, that with regard to the statement made in paragraph 13 of the writ petition, deponent begs to state that in an email dated 4/8/2025, Secretary of GBT apprised DGCA headquarters along with supporting documents such as deed of agreement, deed of declaration, and acknowledgement that all equipment and tools belonging to CAE Guwahati were handed over to the BT Trust on 30/3/2024. Additionally, though the board of a board resolution, BT Trust has nominated Dr. Chandradhar Panda as the new accountable manager. And paragraph number 17, your lordship, that with regard to the statement made in paragraph 15 of the writ petition, deponent begs to state that the reappointment of Dr. Chandradhar Panda as new accountable manager, the application for renewal of approval was considered based on past surveillance records and future of ongoing students' future career prospects. Thereafter, application for change of location was approved after verification of facilities and other requirements as per CAR 47 district. Paragraph number 19, Your Lordship. The deed of agreement, all legal rights have been transferred to BBET Trust, and now the petitioner has created interference for conduct of classes as well as smooth shifting of facilities from Guwahati to Gunupur, Orissa, which is a complete violation of the deed of agreement which he has signed with BBET. Everything is under the agreement only. Everything is doing out of it. That paragraph number 20, Your Lordship, that with regard to the statement made in paragraph 18 of the writ petition, the deponent begs to state that the application for renewal of approval was considered based on past surveillance records and future ongoing students' future career prospects. Thereafter, application for change of location was approved after verification of facilities and other requirements as per CAR 147 basis. DGCA headquarters had honored the deed of agreement and considered the future of students for approval of change of location from Guwahati to Gunupur, Orissa. Paragraph number 21. That with regard to the statement made in paragraph 19 of the writ petition, deponent begs to state that as per 147.A.105 personnel requirements, the organization shall appoint an accountable manager who has corporate authority for ensuring that all training commitments can be financed and carried out to the standards required by this CAR. As BBET Trust, through a board resolution, has nominated Dr. Chandradas Panda as the new accountable manager, and as per the deed of agreement, all legal rights have been transferred to BBET Trust. So Chandradas Panda has been accepted as accountable manager, which complied the CAR 147 basic regulations for acceptance of accountability. And paragraph number 22, Your Lordship, that with regard to the statement made in paragraph 20 of the writ petition, deponent begs to state that the petitioner himself signed the deed of agreement for handover and change of location from Guwahati to Gunupur, Orissa. However, he has created obstruction for conducting the regular classes and change of location of the institute by dishonoring the code of law. He himself is responsible for creating such situation and makes the future of students in stake.
The
Lordship.
deed of agreement is part of the affidavit,
Yes, yes.
page number.
Deed of agreement, I have not annexed, Your Lordship, since it is in the writ petition. I have mentioned.
It is already annexed in the petition.
And in which paragraph of the agreement it is stated that the petitioner himself signed and no, the petitioner.
Yes, in page number 96, I have mentioned, Your Lordship, in the paragraph number 2.
The petitioner has acted for change of location from Guwahati to Gunupur, Orissa, where it is stated. In which part of the agreement?
Your Lordship, in page number 96, the deed of agreement of page 4, para 3, page 42 of the writ petition, Sri Vikram Singh clearly mentioned that on the strength of his deed, deed may create, establish GIETU College of Aeronautical Engineer with a new accountable managers to be nominated.
Page number?
Page number 42, Your Lordship.
Paragraph number?
42 of the writ petition, Your Lordship. Writ petition.
Paragraph number?
Paragraph number 10, Your Lordship. Para number 3, Your Lordship.
No, in page number 42, there is no paragraph number, para number.
There are 242, page number 240, 42 page number is, he has repeated, Your Lordship, 42 page number are there.
Okay.
Paragraph number 3. That paragraph number 3 I am reading, Your Lordship.
Okay. Mr. Sinha, you have filed your affidavit in, affidavit in reply here,
Yes, Lordship.
page number?
Page number. It is 90. It is 92 to no, this. No,
92 is
no,
their affidavit in opposition.
173. Page number 173. Your Honor, whatever later has been fabricated, I have already explained. I have shown.
No, no. You tell me how you have dealt with this contention made by the respondent in paragraph number 22 in your affidavit in reply.
Yes, Lordship. The deponent denied the correctness of the statement made in paragraph. It is paragraph 22-23 of the affidavit in opposition, which are contrary to the inconsistent with the record of the instant case. The deponent further beg to state and submit that the impugned order are liable to be set aside and quashed by the honorable court, and the petitioner is entitled for the relief as prayed for in the writ petition.
Oh, there is no specific denial in respect of the contention being made in the paragraph number 22.
I'll just go to 22. Yes, Lordship. It is not mentioned here. I missed it. And the thing is, as the agreement, I am not denying the agreement, Lordship. I'm not denying the agreement. Agreement, as per agreement, it should run in a very proper manner. They are supposed to conduct classes. They are supposed to conduct classes as per the CR, Civil Aviation requirement. Students supposed to be taken care of. But Lordship, till December, till in fact January for second week, it was going absolutely fine. But the agreement, I have clearly stated that they will run the institute.
No,
They will
Sinha,
shift the institute.
no, Mr. Sinha, you see, this contention being made in paragraph number 22, having not been denied specifically, it amounts to admission on your part.
Lordship, it is not mentioned. I admit it. It is not specifically mentioned that paragraph 22's.
That
It's
means
a
so,
vague one.
where is your case?
Lordship, that is my writ petition. Lordship.
Pardon?
My writ petition.
Pardon?
Am I asked for a writ petition or? I'm not getting the point.
No, where is your case then?
Lordship, agreement I have signed. It's supposed to run, but the agreement terms and condition has been violated. As I said, Lordship, the CR specifies everything. Without the approval of the DGCA, the student cannot be shifted to Odisha. Because CR says the facility is supposed to be approved wherever it goes. Suppose that accountable manager apply for the location change. Apply for the location change to before the DGCA. DGCA is supposed to inspect that new location and approve that. Then after student can go. It is not like that suddenly student can be brought to Guwahati or to Delhi or to any other place. This is the violation of the agreement. The violation agreement is, there are many violations. The classes are not conducted since January 20. And to cover this point, they have fabricated 3 letters. Lordship, as I said, the letter, whatever goes to the government office, the letter supposed to be received by the peon and it is to be sealed and numbering. This letter, what they are saying that I am troubling them, this letter has got no seal and signature, no seal, no diary number, nothing, Lordship.
Mr.
How can
Sinha,
they?
Mr. Sinha, invoking writ jurisdiction, we cannot decide the disputed question of fact. We are not supposed to examine whether those documents were fabricated or not.
Lordship. Lordship, yes.
So, if you want to challenge the same, you go to appropriate forum. This is
Lordship.
not the proper forum.
But Lordship, they have annexed those letter. They have annexed those letter, and Lordship may see in the face of it, whatever letter I have written to DGCA, that is Annexure 1, Annexure 6, their Annexure 6, page number 162, Lordship. Seal is there, diary number is there. And how can these allegations at Annexure 1, page number 1062, 1062, 1062, 110, 110, all these signature, that same person, same as Falte, who is doing all this illegality, he has put his signature. No diary number, nothing. Lordship, it is true that it cannot be verified immediately, or it cannot be verified by this honorable court. But Lordship, agreement is not, can we accept this agreement as a sale deed? It cannot be accepted as a sale deed. And they have violated the agreement. They have not paid me the money.
You have to go by the terms and conditions
Yes, Lordship. Yes,
in
Lordship.
the agreement.
Agreement, as for agreement, the college should run where I have delegated my power to him. I have delegated my power. I have gone to DGCA that these people are not maintaining. And that is why they have given me power again. I have delegated my power to one person, to be accepted by the DGCA. I have challenged those paper only that DGCA has accepted my accountable managership, that later they have approved my candidature, and again they have gone back to previous one. That is 3-4 paper only I have challenged, Lordship. I have not challenged agreement and all. Whatever they have done, that officer have done, considering the agreement, it is fine. Before come to the dispute, when I have written to them that college is not functioning and you supposed to monitor it, I have written them. I have written to the S. Valte that you are not monitoring. As an inspector, you supposed to monitor the classes are going on, students are benefited or no, students practically is going on or no, because 50% of the practical, 50% of the course supposed to be practical, theory 50% and practical 50%. So that is not conducted. And initially I have approved, I have tie up with AISL, government organization, Air India Engineering Service Limited. But they have not sent their student to those organizations. Violation is there with the agreement. I'm not challenging agreement right now. Because this is not a sale deed, Lordship.
Okay.
Without any,
For further consideration. So next, Tuesday. Heard Mr. Vikram Sinha Locker, the petitioner in person, and Ms. Capcom, Burnett, BPC, appearing for the response. List on Tuesday.
On 18, Lord, next Tuesday. 11, we have.
18, I have one urgent matter.
Then on 20, 20.
May it be
For the hearing.
on 11, can it be done?
20,
11?
11, we have few cases, hearing matters.
Deeply.
Item 2 PM, item number 26.
Applies a lot.
May I please your lordship? Lordship, although your lordship has directed me to take the instructions, lordship, as I am being informed from the department, lordship, they speak some time, lordship. They have requested me to pick the matter if you, with due consent from your lordship on Monday,
Next Monday.
not next,
When?
next Monday.
Next Monday. Heard Mr. Professor, learned counsel for the petitioner. Mr. R.M. Das, learned standing for the respondent in Social Justice and Empowerment Department. And for AG, anybody appearing for AG?
80.
None appears for the respondent, accountant general. Mr. Das, tried for listing the matter on instruction, tried for listing the matter on Monday. Fair allowed, this is the matter on Monday.
Timing items 9. Correct. 9.
Okay, after some time.
Timing item 28.
Yeah.
May I please, your lordship? In this case, I will be led by senior counsel.
My lord, in fact, my lord, so here, my lord, on the last occasion, my lord, what happened if your lordship see paragraph 4 and 5, my lord, of this petition. Well, because of the absence of counsel at that moment, my lord, this thing happened.
No. On that day.
Yes.
The matter was called for.
Once it was called for, my lord, then it was timing, it was passed over.
No,
Then
no. Subsequently, it was called for and the council was informed by the court master.
But at the time, he was not there, my lord. He came at 2, my lord, and his name was only recorded. Anyway, my lord, we are filing the affidavit, my lord, immediately. Your lordship may just, my lord, personal appearance because the officers are in Calcutta, my lord. 3 officers are.
Maybe, but if nobody entered appearance on their behalf, what to do?
My lord?
No. On that day, on repeated call, no one appears for the petitioners,
My lord,
for the present applicants.
my lord, what happened? my
Now
lord?
you are finding fault with the court.
No, I'm not finding fault with the
Then-
court. We are finding, my lord, that, my lord, what happened? My lord, once, my
You
lord,
asked him
my lord,
whether the matter was called or not.
yes, the matter was called, my lord.
Then-
I'm not on that.
Then
My lord,
why you were submitting that in absence of you, the court has passed
No,
the
no,
order?
my lord, the council was not there at that moment. My lord,
Who is responsible for the same?
No, only thing, my lord, what I am
It
saying,
is a display in the court.
I'm only praying, my lord, that the personal affairs may be timing, my lord, dispense with. Let us-
Mr. Sahewala, being the senior advocate,
Yes.
don't try to blame that for.
No, I'm not blaming, I'm sorry, my lord, if that your lordship, I'm not blaming your lordship, my lord.
No, no,
I say that,
your approach is that kind of.
no, I say that, my lord, at the time, my lord, the council was not there, my lord. That is why, my lord, I'm saying. We are filing the affidavit, my lord. Your lordship may presently dispense with the, my lord, personal affairs. If necessary in future, my lord, your lordship may again direct, my lord. But three officers are from Kolkata, my lord.
Maybe let them appear,
My lord, my lord,
let them appear.
my lord, your losses were, my lord, because now three persons are, my lord, in Kolkata, my lord.
Maybe.
My lord. My lord, only, my lord, for six,
No,
my lord,
no,
for six, your losses may dispense with, my
no,
lord.
no. Let them
For
appear.
six, your losses may dispense with, my lord. My lord, your losses may fix another debt, my lord, for
No.
their parents. Any debt, my lord, fix, my lord. Any debt may fix, my lord. Some difficulties there, my lord, because the person, one person is transferred, my lord, some difficulties there. Your lordship may fix any other debt.
No, no. This matter is pending since when?
No, matter is, my lord, 25, my lord.
Maybe.
My lord, we are, and moreover, my lord, they are discussing to, my lord, completely, my lord, comply with the order also, my
You
lord.
comply with the order?
My lord,
What is the
that is
order
why-
on that day?
That is why, my lord, I'm praying that,
So on
the-
6th, you produce the order. We will dispense your
my lord,
presence.
it is only 2 days, my lord, that is why.
Maybe.
My lord, your lordship may fix some other day, my lord,
No.
so that we can, my
No.
lord, do it, my lord.
It's one time matter.
My lord, I'm sorry, my lord, if your losses,
No, no.
for that, my lord, I'm blaming the court. I'm not blaming the court, my lord.
No,
Council was not present, my lord, what I am saying. Some communication gap was there.
no, no
I was-
communication can be, it was displayed in the board.
Board displayed, I'm not
And
saying.
the court master has communicated the matter.
My
In
lord,
spite of that, no one appears.
and at two, my lord, they appeared, and your name, my lord, your lordship directed their name to be entered in the. So only, my lord, for this date, my lord, yeah, I'm playing for that. Your lordship will fix another date, my lord, for this. Because it is only on 6th, my lord, day after tomorrow. Any other day may be fixed.
Sahewala, learned counsel. Senior counsel, assisted officer, M. Sharma. Learned counsel for the citizen. Then it's the delivery for the respondent opposite party. Yes, delivery, what is your summit?
I leave to lordship, your lord, because it's been pending for a year and they have not complied with the order of this honorable court, your lord. No communication in that regard for a long period of time.
So you produce the compliance order. We'll
lord,
discuss with your
No,
present.
some time is required, my lord. I have advised, my lord, today, my lord, I had a discussion, my lord. I advised them, my lord, to it. Some time may be, my lord, granted, my lord. Let it be fixed from other day, my lord.
On the assurance thing made by Mr. Sahewala, learned senior counsel for the applicant, that the order of this court dated what is the date of the order?
22/10/2025.
No, no.
But the original 24/9/2024, your lord. Page number 22 of my petition, your lord.
That the respondent, no, that the applicant said in are willing to comply with the order.
Well, I have advised, my lord. No, not that, I have advised them, my lord. They have to consider, my lord. Practically. Today I have advised them, my lord.
That he has advised the applicants to comply with the order of this court and to grant time to the applicants to comply with the same. The instant application for modification of the order dated 20th-10-2025 is disposed of fixing the matter on next Monday. Tenth November. 10th. Till then, personal appearance of the contempt laws stands dispensed with.
Let it be on 17, my lord. 17.
I'm deeply obliged.
Lordship, I have received instruction, but it is a bit confusing. Because your Lordship, it may go in his favor because in one of the instructions they have given, my lord, no show cause was issued to him, my lord. In that event of the matter, entire proceeding will go, but there was a order for extension of the suspension order. Review was done, my lord. In that event of the matter, Lordship, I may be permitted to give a short date. I'll bring entire with Lordship proceedings on record, my lord. Whatever has happened.
Well, the procedure is that well, after suspension, they have to initiate the DP within a period of 3 months. That is the procedure. If they cannot initiate a DP within 3 months, that they cannot continue the suspension
When
order.
the petitioner was suspended.
Well, he was placed under suspension on 17/3/2025.
Law is
17/3.
that as per Ajay Chaudhary's judgment, my lordship is aware of.
That's all right.
Within 3 months, 90 days, DP, like,
You
review has to be
the
made.
information.
Lordship?
You obtain the required
Yes, my
information.
lord. I'll place it on affidavit, entire lordship instruction I'll get your lordship and I'll place it on affidavit. 10 days be granted, your lordship.
10 days will be too long. The petitioner is under suspension.
Lordship. He was placed under suspension, my lord,
17/3/2025.
17/3. Lordship, we have newly been appointed as a standing
No,
counsel.
maybe only the information is necessary whether his suspension order was reviewed or not. within
Yes, that
the
is
period
there,
of
your
10
lordship.
days.
And what date, my lord?
But review order, I have also, my lord, got the copy of the review order. In the review order, they say that because of pendency of the petition, they are extending the suspension order. There is nothing more than that. The
That
review
is
order
part
should
of
be,
the record.
no, my lord.
Date to petition?
19/6/2025. 9/6/2025.
That cannot be the ground. You see the order, speaking order.
This cannot be the ground for extension of the suspension order. They have to pass a region order for, my lord, requiring the petitioner to keep
Yes,
under.
records will reveal an extension, whether it was done within 90 days, but if he is behind the bars, my lord, unless he come out, he was behind the bars. On the
No, I was-
allegation of POXO, my lord,
I was never arrested, my lord. I was never arrested.
pendency of a criminal case, he was, lordship, probably he was behind the bars. Never been arrested?
Never been
Okay.
arrested.
Lordship, I'll take specific instruction and place it on affidavit, my. Say 10 days or can it be 2 weeks, your lordship?
No, no, no.
Lordship, 10 days, I'll put it on affidavit. If it doesn't follow the lordship,
Why don't you obtain the verbal instruction?
That will do, my lord.
Whether it is reviewed within the period of 90 days or not. And going by this order, can
My
I
lord.
say that it is a just order, just and legal order, or extension of the suspension period?
Review order.
Whether it is in terms of the judgment of the Supreme Court in Ojai Sodhi,
may not, no.
then
And 6 of it, no?
Nine.
When he was suspended,
17/3/2025,
17/3,
17/3.
and this order was passed on 9/6/2023.
My lord. Within 3 months, they have done, but my lord, they have to pass a return order. That is one aspect. The other aspect is, my lord, within 90 days, they have to initiate the departmental proceeding. Without initiating the departmental proceeding within 90 days, they cannot continue with the suspension order also.
No, no, Lordship, within 90 days, review has to be made, my lord, and reason has to be cited. The note sheet will reveal whether they have cited any reasons in a note sheet, my lord, whether
Oh, this-
the
this
ground of
order is
review.
there.
9/6 is there, your lordship.
Is there any reason?
But they have stated is made a reason extension till he is fully exonerated. Order, my lord, the last
Exonerated from the service,
charges.
is it?
So whether it was backed by any reason, the ground of review, I'll take that instruction,
You do one thing, you produce the record. We'll
Lordship.
grant you 1 week time.
my lord. It will do.
Pardon me, sir. I.S. Soikia, learned counsel for the petitioner. Yes. P. Bhuya, learned senior counsel. And Mr. A. Hussain, learned counsel for the standing counsel for the respondent number 6. And Madam, secondary education. Secondary. During the course of deliberation, Mr. Soikia has produced one speaking order dated 9th of June 2025. And parallel of the same indicates that the respondent authorities have reviewed the suspension order. Suspension order. And in view of the case pending before this court, the respondent authorities have extended the suspension of the petitioner till he is fully exonerated by this court. By this court. In view of the submission advanced by learned counsel for the petitioner and also in view of the speaking order dated 9th of June 2025, Ms. Bhuya, learned standing counsel for the BTC, is directed to produce the relevant file before this court on 1 week.
On 17 November.
17.
2 weeks ago.
1 week.
Lordship, 17th.
One-
On 13, my lord.
Around
Thirteen.
13, Lord. 13,
13.
13, 13.
Published.
13th to 8 huh?
Thursday.
That's the time.
Items for hearing. Item number 17 and 18.
In, may I please, sir. In item number 17, Lordship, I am the appellant, and in 18, I am the respondent number 1.
Two appeal arising out of the same decision.
Same, Judge.
Both
Your
are on
pair is
one
for
part.
enhancement. Your pair is for enhancement.
Yes, Lord.
Death case or
Date case, Lord.
injury case.
Date case, Lord.
What is the ground for enhancement?
I'm challenging on three counts, Lordship. First, my income was wrongly calculated. Second is
Income
multiplier
was
wrongly calculated, Lordship. And second one is multiplier.
pardon. One is income was wrongly calculated.
Yes, Lordship.
How?
Because I was my son, I am the mother of the deceased son, Lordship, who is the claimant, Lordship. Son was working as doctor, Lordship. He was working in 3 institutes. Only income from 2 institutes has been considered, and accordingly the income was calculated. The third source of income has not been taken consideration.
What are the sources of income?
He was working in three institute, Lordship. Mediscan Diagnostic Center, Poverty Nursing Home, and
Number two,
Mediscan Diagnostic Center, one, Lordship. The second one is Poverty Nursing Home, and the third one is a Dr. NMB Borua Nursing Home, Nalbari, Lordship.
what was his profession?
He was a doctor, Lordship.
And whether there was any document to substantiate your claim that he was working in three different institutions?
But regarding two institute, there was evidence, Lordship. The authorities have been called and they have been examined, Lordship. Regarding third one, Lordship, they have not produced any documentary and neither called any authorities, Lordship.
Then?
But there are judgment, Lordship, in MSCT cases, the documentary evidence is not required. That has to be
No,
estimated by
not in all aspects.
Lordship.
If you claim that your income is 1 crore during
Lordship.
that period,
Lordship, but
without any document, can we believe it?
Lordship, the claimant has submitted her evidence on affidavit. They have not, during cross-examination, she stood with that affidavit, Lordship.
Hmm.
They, in cross-examination, they could not find out anything that he was
Maybe.
not,
Even
Even-
that
even-
was not disputed, are you not supposed to prove your case?
yes, Lordship.
Only
In-
making
in-
a statement that you have been working in another institution apart from working in two institutions.
Lordship,
Can it be believed?
in that case also, Lordship, even if Lordship consider my income from only two institutes, then also it has to be enhanced, Lordship. Because
No, whether the tribunal has not considered the income of the two institutions.
is it to be the learned trial just considered my income from two institutes, Lordship.
Then
Not regarding not consideration of third income source, Lordship, he has not given any reason, Lordship. He simply does not consider it. Whether in my
absence of any document,
Lordship, then
can this
also
court consider it without any document?
if then also he should have at least considered that in that regard, the claimant could not produce any documents, so I will not consider. That regard also he has not stated anything, Lordship.
No. If you want that this court has to consider it,
Yes, ma'am.
can this court consider it without any documentary proof?
Lordship,
Merely on the basis of your affidavit, I can grant the relief.
my submission is that, Lordship, I leave it to Lordship consideration, Lordship.
No. Illogical. Without any document,
Lordship,
without a person being examined
yes,
from
Lordship.
the said
Yes,
institution,
Lordship.
can we believe it?
Because she submitted her affidavit in evidence on affidavit, Lordship. On that basis, Lordship, since in cross-examination, she did not denied, Lordship, that one. So on that basis, it
Yes,
could be
that is a wrong calculation of the income.
income.
What is the number two?
A wrong selection of multiplier, Lordship.
Wrong selection. What was the age of the person concerned?
Age was at the time of death, he was 28 years, 7 months and 11 days. That means 29 years around, Lordship. 29 years, Lordship.
29 years.
Yes, Lordship.
And as per this decision of Sarla Verma,
The
what is the
multiplier
market
should have been 17, Lordship.
17. As per Sarla Verma.
Yes, Lordship. But multiplier was taken as 9 only, Lordship.
9.
9.
Why? Whether any document regarding proof of age was
Yes, Lordship. In the judgment, he has relied also, Lordship. It was submitted. He submitted the HSLC pass certificate, Lordship. And as per that, he taken the age as correctly 29 years, Lordship, but wrongly selected the multiplier. The learned trial just even gone to the extent of relied the Sarala Verma case also. But he has referred a wrong provision. In the Sarala Verma case, Lordship, while passing the judgment, they have referred a previous judgment and quoted that one. The learned trial just on that quoted.
no, one cert is given in the Sarla Verma case regarding the multiplier.
Multiplier has to be taken on the basis of the date of the disease, on the age of the disease.
Cert is given in the Sarla Verma's decision. That cert has to be followed.
Yes, Lordship. According to that, Lordship, it has to be 17, Lordship.
17.
Yes, Lordship.
Mr. Goswami, any dispute on this? Regarding this application of multiplier?
It has become a stepping question.
70.
Probably cannot, but Lordship would recall in another similar instance, I had given a certificate. I'd just like you to have
No,
given here also
no,
in this case.
That's all right, but Mr. Goswami, you see,
Yes.
the decision of Sarla Verma is upheld by the constitutional bench in Konoy case. The constitutional bench decision is there. So there is no scope for any interpretation.
I understand lots of this honorable court or any high court cannot probably go against that. This is not fight judgment can pronounce it. But I've been holding this view and accordingly I submitted. In another case also I had submitted before Lordship. It was this time also I'm just keeping it on record. So I've only filed on 1/10/2024. The Lordship had recorded that he has taken time to go to my written certificate. Lordship, I'll not push this point beyond because I know it's a self-question. I know this Honorable High Court cannot go beyond.
Okay.
But Lordship,
What is your?
I want just want my submissions to be recorded, Lordship.
Okay.
As per this.
What is your third point?
It is interest part, Lordship.
Interest.
6% interest was implied, but it should have been 9% according to Upahar tragedy case, Lordship.
But whether this decision of Upahar tragedy case was placed before the tribunal?
It was not placed right now,
Not
Lordship.
placed. Okay. So these are the 3 points.
3 points.
Okay. Mr. Goswami, now come
Uh,
to your point.
Lordship, I'll submit one calculation. If your Lordship consider my income from 2 sources, then also my quantum has to be increased. If your
Furnish it
Lordship
to-
consider 3
Furnish it to
sources,
court, Master.
then also, yes.
Then furnish a copy to Mr. Goswami also.
That's okay. I'll calculation. No. Yes, yes. Yes. Should I place the judgment in this regard case laws? I want to
respect
cite
of?
some case laws also. I have marked
Respect of?
with respect to the interest part and that regarding documentary evidence with regard to calculation of income. And one is that regarding multiplier laws.
No, multiplier is well settled.
Yes, that's
Then in respect of calculation, if no documentary proof is produced before the learned tribunal and also before this court, how can we increase the amount? Okay, you produce it to the court.
Yes, Lordship. I have marked the paragraph, Lordship, in the judgment.
Mr. Gupta,
Lordship, now as regards his points, Lordship, income, Lordship, my humble submission that learned tribunal has considered only what was placed before it to show income from three sources. But Lordship, I'd like to Lordship, take your Lordship to the position of PW number 3. PW number
is part of the record.
to be part of the record. So it is the position of one of the employer. That is, he is the employer in Mediscan Diagnostics. PW. It's already, as per his calculation, 1 crore 73 lakhs. So I'm just trying to knock off 20. 1 crore 73 lakhs. I'm just trying to. Yeah, that's right. That's only a part of it. It will not make much of a dent, but PW3, Dr. Jitendra Soni.
No, you have enclosed the deposition in your appeal. No,
It's a part of the record.
main record.
The record. No. PW3. Dr. Jitendra Sharma. I'll read out what was stated in the oath. I'm a registered medical practitioner radiologist and I have a diagnostic center at Nalbari town. Under a name and style Mediscan Diagnostics, late Bhavesh Mujumdar used to work honorarily in my state diagnostic center and I used to pay him honorarium as per work done by him. He worked in my diagnostic center only for 3 months and I paid him honorarium of rupees 20,500, 25,600 and 38,000 in those 3 months respective. Now coming to the cross part, Lordship. I did not maintain any register to prove that Dr. Bhavesh Mujumdar used to work in my diagnostic center. It is not a fact that late Dr. Bhavesh Mujumdar did not work in my state diagnostic center, and as I knew him, I deposed falsely. I have not brought any document to prove that I paid Dr. Bhavesh Mujumdar honorarium of rupees 20,500, 25,600 and 38,000 in those 3 months. Lordship, I am not disputing the first appointment of 55,000. He was where he was working as a full time. This part, since he has said that he also works additionally. Now there should be some good evidence about. In this case, the employer has come and deposed, but without any document. And Lordship, another point, look. We just had worked for 3 months and it seems to be a very varying figure. 20,500, 25,600 and 38,000. That's it. And the only total, the highest of these 3 figures have been taken to. But even if an average is taken, it comes to 28. Not much of a year. But it will make a difference. Small difference, but first thing it was based on without average. Secondly, even accepting those 3 figures, only the highest was taken. Yeah, my humble submission. If only
Should
an
be
average
average.
is taken.
According to you, average should be taken.
No, because it's not a, and he worked only for 3 months, not to, even a pattern cannot be discerned from it. So even if some credit has to be given for a deposition made by him without documents,
Then I'll say the interest of fairness, maybe an average. Apart from that, Lordship, this is one point I would not like to. Then that this statutory deduction, Lordship, it's something, it's a law, legal point. Statutory deduction, even in his calculation now, it's a wrong calculation for that year. It is a wrong statutory deduction. Income tax has been incorrectly calculated. It should be 1,64,800 as per financial year that some year with me. And only 91,600 has been fixed. It's not a flat 10%. At that point of time, just 2.5 lakh to 5 lakhs, 10%. 5 lakhs to 10 lakhs, it is Lordship 20%. And above that, it was 30%. From that point of view, it should be 1,64,800. Whereas only 91,600. These two lots. If the income is little modified, then this statement will also become a little modified. Lordship, I have a structure of that year, Lordship. Well, what should be the year? I have a structure of that. Income tax calculation. Lordship, this is the structure I had downloaded. Here, like he has taken from the judgment, I'll understand in his calculation. It is straight 10%, it is never like that. Up to 2,50,000 and 250 to 5 lakhs, 5 lakhs and above. So even if that entire his income is taken, then income tax deduction should be 1,64,800. If it comes down, this figure will also come. This is my only thing as regards interest, Lordship. It always depends on if the discussion on honorable court. Where the figure itself is so high, I'm only praying that that should be retained. 9% is the highest in any case. Hardly allowed more than 9%. So my submission is, I cannot really argue on the discussion basis. I can only show certain there are also various citations like question note as on yes. Depends on the bank rate, prevailing bank rate. That's the law. Prevailing bank rate. Otherwise, interest keeps fluctuating. And Kosnuma Begum versus New India, it is stated the prevailing bank rate of interest. And the fixed rate is now 7.5% in all banks. Almost.
When the accident took place.
That's it.
India year 2014 looks.
14.
14.
From that point of time, it has been more or less like that. Last one decade was hovering from, even if now, for I'm a very senior citizen, for me it's 7.5%.
But those the decision of Supreme Courts are there.
That's
Supreme Court is there.
No, as per Kosnuma Begum, that's the only judgment that has given a rational reason why, how and how interest is fixed. I'm just making a humble submission. It's always they say that it's based the prevailing bank rate of interest. At that point, of course, it has to be at the point when the judgment is rendered. Otherwise, it will be difficult to trace out 10 years, 15 years back. It always becomes a lot of hard digging work. What it is. And as regard Lordship, my only submission, Lordship, my I found record Lordship that may be referred to. And I'd continue to make that submission.
Lordship, regarding that amount of salary, 20,500, 25,600 and 38,000, taking consideration of only 38,000 Lordship, it can be seen that Lordship, this salary is increasing. From 20,000 to he is getting 25,000 Lordship, and thereafter he is getting 38,000. Maybe he could have get higher salary thereafter Lordship. So considering 38,000 as salary from that institute is right, Lordship. In my submission, Lordship.
He was working full time in Andhra Institute as a doctor. How much time he could have given that also?
Because of that only his salary was increasing, Lordship.
Okay. Art. Sir.
AD
So do we learn it for the appellant? Definitely appeal for
6:30.
6:38 of 2007. Sir, are something? Learn it for the response. And sir, are started okay for the FLS in MSc appeal now for 469 of 2006. So the response argument concluded. Judgment reserved.
Obliged. My lordship, here, as it shows reflected in the order letter 9-9, there's some amicable settlement discussion is going on. So lordship will be filing affidavit to that regard. Some deliberations are going on, 1 week time if lordship allows kindly then.
1 week time.
Yes, lordship.
Okay.
As per instruction received by us.
Mr. Sikar,
Yes, ma'am.
okay. As agreed by learned advocates of both the parties, it is provided that there is a list of matter on, okay.
13th.
13.
Only.
13.
Item 20. Your lordship, actually against the affidavit that was filed by the department, additional affidavit in opposition, we are supposed to file rejoinder. But lordship, meanwhile, we have got access to some relevant documents. So we will bring all those on record. So if lordship allows, 10 days time, we'll file their lordship.
Art Mr. Andrew Chaudhary, learned counsel. Appearing on behalf of Mr. A.R. Cohen, learned for the petition. And also heard Mr. Sikdar is here?
No.
No, you are. Mr. Bora is here.
Elementary Education Department.
Mr. Bora, learned standing counsel for the elementary education department. So Chaudhary submits that the petitioner will file a rejoinder. The affidavit in opposition filed by the.
Filed by the
SSM.
Yes,
SSM. And the best for this the matter after 1 week. There ago, this the matter of.
20. Items 21 and 22.
My lord, my humble query is that this matter may also be taken up on Thursday. The other matter was fixed on Thursday.
13. Okay. And agreed by learned advocates of both the parties, that's the matter.
Item 24.
Please, your lordship.
Yes.
Lordship, the matter here pertains to the appointment of the petitioner with regard to the post of assistant professor in the zoology subject of Bilasipara College, lordship. Now, lordship, the petitioner was issued a call letter in the year 1999 to appear before the selection committee for interview for the said post. Page 20 is the call letter, lordship.
Advertisement was published in which year?
Lordship,
Is it part of the record, advertisement
no, lordship. I have annexed the call letter, lordship.
only?
Lordship. That
Page
is at
number?
page 20, lordship. Selection of candidate for the post in zoology. With reference to the subject indicated above, you are hereby invited to appear before the selection committee for interview for the post of lecturer in zoology in Bilasipara College on 7th April 1999 at 10 a.m. in the college premises. Pursuant to that, lordship, page 22 is the appointment letter, lordship. The appointment of lecturer issued to the petitioner. Page 22. Then lordship, page 29 is the provincialization order of the college, lordship.
Page 29.
29, lordship. This is an order of 20 January 2014. And with effect from 1/1/2013, the college was provincialized.
The petitioner service was not provincial.
Not provincial. In place of her, serial number 9, Abdul Ghaffar Ahmed, Assistant Professor Zoology, 21/9/2004. Now, Lordship, if Lordship observes the date of joining, that was much later, Lordship, later than the petitioner, because the petitioner joined her service pursuant to the appointment letter issued on 9/4/99, and he was appointed on date of joining is 21/1/2004, Lordship. So, index context, Lordship, page 31 is the type copy wherein the petitioner was held to be underqualified.
The petitioner was appointed on
9/4/1999.
1999.
Lordship.
And this 9, Abdul Ghaffar Ahmed
Lordship.
was appointed.
21/9/2004, Lordship. So admittedly, he is junior than the petitioner, Lordship. Then Lordship, Lordship may come to page 31. It is a statement for provincialization.
Yes.
Dear Lordship, Lordship will find this is the petitioner, Mrs. Moitri Chakravarti, designated assistant professor, date of joining 9/4/1999, and she was held to be underqualified because she obtained her MPhil degree after 10/7/2009. She was held to be underqualified, Lordship. Now, Lordship, at that point of time, net plate, Lordship, and MPhil was not mandatory. There are notifications I have annexed. At that point of time, Lordship.
May not be at the time of her appointment, but at the time of provincialization of the college.
Lordship.
What was the prevailing UGC norms? It was provincialized on 28 January 2014.
Lordship, with effect from 13.
So we have to consider her qualification on that point, on that day.
Lordship.
What was the UGC norms on that day?
Lordship,
28th of January 2014.
Lordship, since the period 99, Lordship, I want to show a notification wherein net slate was not mandatory during that relevant point of time.
No. At that time, the college was private college.
Lordship.
At that point of time, college was private college.
Lordship. When she was
Provincialized in the year
appointed, Lordship.
2014.
Lordship.
So we'll only consider at the time of provincialization what was her qualification and what was the norms of the UGC.
She was held to be underqualified, Lordship. At the time, MPhil was not
passed.
Lordship.
And the petitioner did not possess the MPhil.
MPhil, but the private respondent not there. The other side, junior colleague, he had the MPhil qualification, but his date of joining is later than the petitioner.
Maybe he's qualified. He
was
possessed
held
the
to be
requisite
qualified.
qualification as prescribed by the UGC.
Lordship. I want to show one notification. That is page 49. Lordship may have a look once.
Yes.
That is office memorandum. It was issued exemption of MPhil, NET, SLATE, PhD who have been appointed as assistant professors, librarians between 24/12/1998 to 31/1/2000 in the degree colleges of Assam. So, Lordship, I would like to read the second last paragraph. In view of the above and with reference to the provisions of 4.3 of the Assam Venture Education Provincialization of Services Act 2011 Amended Act 2012-2013, Government in Higher Education Department has decided to consider the assistant professors, librarians who were appointed by the college authority governing body of the colleges between 24/12/1998 to 13/1/2000 as qualified, exempting them from MPhil, NET, SLATE, PhD qualification if they were otherwise qualified as per UGC qualifications required then. This was followed, Lordship, at that relevant point of time. My case is also with regard to that. The petitioner should have been, Lordship, provincialized. as he is senior to the Abdul Ghaffar Lordship. Now, Lordship, that Abdul Ghaffar, he had already expired and the post is lying vacant. That is my case, Lordship.
Yes, Mr. Das.
Here, the prayer of the petitioner is that his petitioner sees taking provincialization in the third or fourth post product, and if can we have the prayer? Prayer is at page 17, my lord. From the middle, my lord, shall not be issued directing the respondent authority to provincialize the services of the petitioner as assistant professor in the Department of Geology of Vilasibara College, either in the third post or fourth post in UGC School of Pay. Now, my lord, it is admitted by, as my learned friend has already shown, my lord, page 29, whereby the services of the incumbents were provincialized under the 2011 Act, my lord. There are already 3 posts are provincialized at that point of time when the college was.
No, that's all right.
Now, my lord,
Now, you see, this person has already suffered demise. The post is lying vacant.
Vacant, Lord.
Then, my lord, this post has to be, my lord, advertised by in view of, my lord, 2017 Act, my lord. Because this is a direct requirement. That at that point of time, my lord, those posts were provincialized because persons were, the college was venture, then persons were employed in venture stage. Then, my lord, this act came and those persons who were working in a venture college, they were provincialized as per the, my lord, 2017 Act, 11 Act, earlier 11, then, my lord, 17. Now, the petitioner is claiming at the third or fourth post, my lord. Third post is already, my lord, third 3 candidates has already been provincialized by way of this order. See, the petitioner was working the fourth post. For fourth post, my lord, there are other requirement which I'll show, my lord. For that purpose, there has to be, my lord, 180. This is additional post, my lord, third, fourth post. It has to be 180 students in the last final examination, which the college doesn't have at that point of time. In my affidavit also, I have categorically stated.
Lordship, with regard to petitioner on the basis of seniority, petitioner is in the third number. First 2 posts are already occupied, they are working. Third post, Lordship, the respondents have appointed late Abdul Ghaffar. Now third post is lying vacant. Otherwise also, Lordship, since MPhil was not a mandatory requirement, then petitioner is automatically senior, Lordship. I've stated in my petition, Lordship.
My lord, in this petition, my lord, the petitioner has the claim, they say that Abdul Ghaffar Ahmed, he was wrongly provincialized. However, my lord, this provincialized order has not been challenged here. Neither that person was made party or
It
his
is
legal
already
heirs,
expired, Lordship.
or all legal heirs, my lord, or neither that order has been challenged here.
Lordship, that
And, my
was
lord, kindly,
No, maybe, Mr. Das,
that third post is lying vacant.
on
Lordship.
the relief, though it is not there in the petition.
Another document is there, Lordship, where she is shown as qualified. That is also issued by the Director Higher Education, page 52, if Lordship peruses page 52. Statement showing the
So,
eligibility of.
as per this page number 49, Annexure M, the MPhil
Next,
nets that are not compulsory,
who were appointed during this period, Lordship. So
98 to 2000.
98 to 2000, and the petitioner was appointed on 9/4/1999. So this hasn't followed, Lordship, with regard to other appointments. This notification has been followed. Only between this period, Lordship. Otherwise, MPhil net slate is a mandatory requirement now, Lordship. The persons appointed during this period, they are exempted from having this qualification. If this notification is taken into consideration, she was left out, Lordship. Because on the basis of seniority, she occupies the third place. First 2 post already they are working, Lordship. Third post, her name comes, but the respondents have appointed late Abdul Ghaffar, Lordship. And now that third post is lying vacant, Lord.
You are referring to another document?
Page
Which document?
52, Lordship. Page 52,
52.
Lordship.
Qualified.
Lordship, she was held to be qualified, Lordship. This is a statement showing the eligibility of post and persons eligible for provincialization of services as per Assam Venture Educational Institution Provincialization of Services Act 2011 and amended 2012 in respect of degree colleges of Assam. In this regard, two persons named are there. First person, Lordship, serial number 1, Assistant Professor, Mrs. Maitri Chakravarti. So and so, date of joining 9/4/1999. And TC of mark, and she is held to be qualified. This was issued pursuant to a letter by issued by the director to the commissioner, page 50. The subject of the letter is creation of post for provincialization services of the employees of the venture degree colleges. And with regard to that, the second last paragraph of the same page, Lordship. Accordingly, in pursuance of the government OM number so and so, the Directorate of Higher Education has examined and verified the documents of 134 numbers of colleges and found that the services of underqualified employees of venture degree colleges may be provincial as per the Assam Venture Education Institution Provincial Services Act 2011 amended 2012 and 2013. So with regard to this, Lordship, this is the statement showing the petitioner as qualified.
This statement is updated.
Lordship, this statement is with regard to the letter,
11
Lordship, that
February
is 11 February
2014.
2014, Lordship.
It was prior to provincialization or after the provincialization?
This is after provincialization, Lordship,
After
because,
provincialization.
Lordship, because the provincialization order is of 21/2014, Lordship, and this is of, wait, 52.
11 February.
11 February, Lordship.
Okay. Then what is page number 53?
Lordship. This is a higher education communication, Lordship. View of the judicial department regarding the provincialization of services of the petitioner and other similarly situated assistant professor. This is the view of the judicial department. Lordship. The last paragraph is relevant here, page 54, Lordship. Therefore, in the attending facts and circumstances of the case, the department may examine the propriety of framing a policy to exempt appointees who joined between 14/1/2000 till actual implementation of net slate, that is 20/2003, taking into consideration the recent OM dated 7/2014 and take an appropriate decision.
Sir, does?
Yes, my lord.
This is your letter.
Which one?
The statement is number 52. Petitioner is qualified.
52.
This is my lord under Act of 2011. Now, my lord, she comes under, the petitioner comes under 2017, my lord. But two things are there, my lord. Earlier, when the provincialization was done, my lord, the letter in page 29.
No.
Then, my lord,
Her
that
case
province,
is to be
the post,
considered in the earlier act.
my lord, the post were provincialized by the name, my lord. If the post were at the time of initial provincialization, the post were provincialization by persons, my lord.
Hereafter, their retirement, after their retirement or expired, my lord, that post abolished, my lord. Then the vacancy has to be filled up by way of, my lord, under direct recruitment.
No, that's all right.
So now at this moment, my lord, the petitioner cannot say that this person has expired and this post is lying
No, no.
vacant. It has to be-
He has prayed for provincialization of service in place of that person.
That person, my lord. The third candidate, my lord, Abdul Ghaffar Ahmed, my lord.
Hmm.
But interestingly, that provincialization order has never been put to challenge. Not here in this petition also.
My contention is that the person has already expired and the post is lying vacant and I'm already working since 99. And also I was eligible at the time of provincialization since NetSlate was exempt at that time. They have inadvertently appointed the Abdul Ghaffar. Now that since the post is lying vacant and I'm working since 99, I'm eligible to get the provincialization of services. Lordship. It's a long time she's been rendering service. Lordship.
Mr. Das,
Yes,
please. When the college was provincialized,
Lordship, the order is of 21/2014.
That is the provincialization of, no.
The science stream
The
was
provincialization was
provincialized.
done on 1/1/2013. Kindly have page
With
29,
effect
my
from
lord.
1/1.
The college was provincialized, then the employees working there in the venture stage, they were provincialized on 20th of January 2014, month.
no, she has challenged the order. You come to page number 2. So in the pair, it is not there.
Prayer portion and it is not there, my lord. And my lord, it is very clear that if there is no prayer, specific prayer, my lord,
No, in the course title, it is there.
house title,
Page number 2, last.
my lord, this is not
And
part
in the
of
mid-
prayer, my lord. This is not part of, in my humble submission, this is not part of prayer.
So does you say under Article 226, this court is exercising equitable jurisdiction. So it is not there in the pair person, she has challenged the order. It is there in the course title.
Now, my lord, regarding this third post, my lord, he is saying that since the person has already expired, it becomes vacant and he needs to be provincialized. Now, my lord, condition is that at this moment, this college become provincialized college, my lord. Now, whether for provincialized college, my lord, for that post,
Advertisement has to be made.
Advertisement has to be made, my lord, for
But,
direct recruitment, because otherwise, my lord,
No, but while
same
the
kind of post which were earlier provincialized, automatically they will vacant one day, my lord. If my lord, kindly have a situation, my lord. If the petitioner is provincialized in that post, tomorrow she will also get retired. Whether another person can come on after her retirement, that okay, she was provincialized.
no, that cannot be there. She has been working since
99.
1999.
Then, my lord, we have to see, kindly have just a minute, my lord.
Another thing,
Page, my lord, kindly have page 108, my lord,
Hmm.
of this book, my lord.
No, you
There
are
are some
referring to
requirement, my lord.
2017 Act.
79, my lord. There are some
Her case has to be considered under the earlier act.
2011, my lord.
Yeah.
Now this act is struck down, my lord. And there are judgments I'll place, my lord. There are judgments which says that once the act is, my lord, struck down, then it
No,
is supposed, then
provision is there. Repeal and saving provisions are there.
saving provision that will be decided by the, my lord, saving provision, yes, saving provision is there for, but not for giving employment to under the struck down act, my lord.
in my humble submission. This saving provision is there if saving provision is for those persons which has already got benefit under the 2011 Act, my lord, who have already been provincialized under the 2011 Act. After starting out of that Act, those person doesn't get affected. For those
What is
persons,
the judgment we'll take?
yes, my lord. I'll, if my lord, give me some time, my lord, and under that I'll place those judgments, my lord. For, I remember, my lord, those judgments for struck down Act, I'll be relying on judgment State of Manipur versus Surya Kumar Okram, my lord. And regarding this saving clause, my lord, there are judgments in our High Court Purnavati Brahma is there, my lord. WPC 283, writ appeal 283 of 19.
Okay, you produce it.
Yes, my lord.
Heard Ms. Talukdar, learned counsel for the petitioner, and Mr. S. Das, learned standing counsel for the respondent in Higher Education Department. Argument concluded. Place the matter on
20, Lord, 20,
for that
18.
18. So as to enable Mr. Das to produce relevant judgment.
I'll also submit a little bit, my lord, regarding
No.
to substantiate my lord.
You
Because,
produce the
because
decision.
her claim is something else, my lord, because she is claiming that vacancy is saying that this has become vacant and
No, that is her additional submission.
yes, ma'am.
Her main claim is for that post in which Mr. Abdul
I have
Ghaffur was
the
appointed.
third or fourth post, Lordship. Third post is lying vacant, Lordship. That was accommodated to the late Abdul Ghaffur. That is my only prayer, Lordship. And also working since 99, Lordship.
Okay.